No speaker shall be allowed to plead for more than 25 minutes. Team representing the applicant or respondent in a round may reserve up to 5 minutes of their time for rebuttal or sur-rebuttal. Only one team member may argue on rebuttal or sur-rebuttal. During the oral arguments, laptops, phones, and other similar electronic devices are not permitted. The electronic devices without internet connection is permitted. No communication at the council table while the speaker is speaking. I request everyone present in the courtroom to put their phones on silent mode. Speaker 1 from petitioner side may approach the dais.
A very good morning to the Honorable Bench. May it please the Court, the counsel for the petitioner seeks permission to address this Honorable Bench as Your Honours. Much obliged, Your Honours. Your Honours, I'm counsel number 1, and I appear on behalf of the petitioner, Mr. Tayyab Raza, in this action. If Your Honours are sufficiently familiar with the facts of the case, the counsel would like to seek permission to proceed with the pleadings. Much obliged, Your Honour. Your Honour, as counsel number 1 for the petitioner, I will be dealing with issues 1 to 3 on originality, copyrightability, as well as authorship. Now, I would like to proceed with the arguments on issue 3, which deals with the important issue of originality in this case. Your Honours, issue number 3 deals with whether AI challenges the doctrine of originality as it stands in Indiana. On behalf of the petitioners, it is contended that no, AI does not challenge the doctrine of originality under Indiana's copyright law. Your Honours, as you would know, the threshold of originality was set in the landmark case of Eastern Book Company versus D.B. Modak 2008. In that case, this Honorable Court set the standard of originality as skill and judgment with a minimum degree of creativity. I would like to establish how the said work in this case, Dhwani, fulfills both the requirements of skill and judgment as well as minimum degree of creativity. Firstly, I would like to persuade Your Honours as to why the element of skill and judgment is present in the creation of Dhwani. Here, the petitioner has exercised his musical skill and judgment in configuring the AI tool Amit. Amit stands for Autonomous Music Invention Tool. He had used this AI tool, he had set certain parameters, inputted some prompts, and he had created Dhwani using his musical skill and judgment. It definitely took his expertise and his knowledge in music theory to come up with such a beautiful creation. And we would like to assert that the process involved careful discernment and a lot of choices, and aesthetic and musical choices on the part of both the petitioner, Mr. Tayyab Raza, who inputted the prompts, as well as the AI tool, which plays a primary role in selection, arrangement, and coordination of the track. Secondly, Your Honours, I would like to tell you why Dhwani satisfies the requirement of minimum degree of creativity. We believe that Dhwani is not just a generic arrangement, but it's a unique composition where both the AI and the petitioner, again, have reflected their creative choices in it. The primary creative process here remains with Amit, the AI invention tool. However, the petitioner has also shown his creativity through the prompts and through customizing the output, that is Dhwani. So what we're trying to say is that there was some level of intellectual effort that went into the creation of Dhwani, and it was a result of deliberate artistic choices and not just an automated output or something which is a mechanical reproduction of tracks, as the respondents may assert. Your Honours, the next point I have, if Your Honours are satisfied with the arguments on originality. My apologies, Your Honour. Yes, Your Honor.
Why not appeal under the Competition Act?
Y-
You are going after this NCLAT decision.
Yes, Your
So
Honor.
why you not prefer to go under the Competition Act? There's a provision under Section 53T for making appeal to the Supreme Court. Why SLP?
So we've preferred an SLP, Your Honor, because it's not only a competition law question, but there's also a matter of copyright law, a violation of fundamental rights. And so we preferred an SLP under Article 136 because we believe it involves a substantial question of law, that of copyright law, which is affecting a large population and the general public. So we preferred an appeal under Article 136.
Just explain us that when you have filed an SLP, not an appeal in the competition law, then the entire issue of the competition law will become irrelevant. Judges will not listen to your arguments.
I understand, Your Honor, but the case had first gone to the NCLT and then appealed to the NCLAT. And after that, Article 136 clearly states that any decision by the tribunal can be appealed before the Supreme Court under Article 136. So that is why we've preferred an appeal. Your Honors, if I may proceed with the arguments. So on the point of originality itself, we would like to present some foreign jurisprudence which supports our point on originality. Firstly, Your Honors, the precedent of Lee versus Liu 2023 very recently, it was decided by the Beijing Internet Court in China, and that court had ruled in favor of copyright protection for AI works. So the Beijing court said that in Lee versus Liu, the plaintiff had used models, prompts, and parameters using this AI named Stable Diffusion model, and he had created artistic images out of it. And this model helped him shape the final artistic work, which reflected his aesthetic choice and judgment.
Counsel, these judgments of foreign law,
Yes, Your Honor.
which are from the foreign country,
Yes, Your Honor.
whether they have any relevance for the purpose of Indian country.
Yes, Your Honor. It would have relevance. It would not have any binding effect, but it would have persuasive value before the Supreme Court.
Fine, fine.
I have a question.
Yes, Your Honor.
So far as this Eastern Book Company judgment of 2008 is concerned, what was the ratio of that judgment, and will that ratio apply in the present case?
Yes, Your Honor. We believe that the ratio of that case would apply. The reasoning behind that was that a certain level of skill and judgment and creative choices, or minimum degree of creativity, as the judgment itself says, was inputted into the work, and that's why it was worthy of copyright protection. And we think the same logic would apply to AI works as well, because it can be accommodated under the Copyright Act. So since that judgment talked about copyrightable works, and we assert that AI work is also copyrightable under the current regime, we would say that the judgment applies.
I understand
Yes.
that in Eastern Book Company's case, the issue related regarding the publication of the judgments of the Supreme Court.
Yes.
So how you distinguish that judgment from the present case?
Okay. So that case involved publication of the Supreme Court judgments, and it was a derivative work in that place, in that case. Because Supreme Court judgments themselves are not copyrightable, but they worked on it, they improved it, they wrote comments, etc. So that made it a derivative work. And in the same fashion, the AI in this case has also come up with a derivative work, because it's made from 4 existing tracks. Those are called Blue Bone, Macro Dosing, Shock Beat, and Beating Beast. So since that case, the EBC case also deal with the derivative work, and we're also dealing with the derivative work at hand, that case would apply in that sense as well. Thank you, Your Honor.
You can proceed further. Okay.
Okay.
May I ask one question?
Yes, yes, yes.
You have spoken about Lee versus Liu case, where the China courts have given, have authorized the registration of AI generated work.
Yes, Your Honor.
Are you aware of similar case which originated in US courts, Stephen versus Shira? where the same request was declined. How you will reconcile the international jurisprudence?
Yes, Your Honor. We understand that there has been conflicting international jurisprudence on the matter. Your Honor had brought up a case from the United States, but we were able to find a case from the United States itself, very recently that too. It was, the judgment was delivered in 30th January 2025, this year. And in that, the US Copyright Office had given copyright to an AI work, and it was wholly generated by AI in that case. There was no human intervention at all. And the US Copyright Office gave it copyright because they said that the selection, coordination, and arrangement in that case met the threshold of originality that the US required. And if I may, the piece is titled A Single Piece of American Cheese, and it was wholly AI generated, and it was, the model used in that case was custom Excel. It was an artistic image that was generated. And we have many more precedents apart from that to support that copyright has been given to AI works. We would like to bring up the case of Suryast in Canada. Suryast is again an artistic image generated by AI. In Canada, the CIPO, the Canadian Intellectual Property Office, in 2021, they had given registration to this AI work. In that case, it was created by a human author using AI, but both were given authorship status and the work was given copyright protection. Your Honors, I would like to rest my arguments on originality and move on to copyrightability, which is the first issue in this case.
All right.
Thank you, Your Honors. Your Honors, the first issue asks whether AI-generated works can be protected under the Copyright Act of 1957 and its moral rights provisions. To support why AI should get copyright under the current regime, we would like to state that the current IPR regime, even though it doesn't include AI, it doesn't exclude it per se, or expressly exclude or impliedly exclude it. And we believe that the definition of author and copyrightability under the Act should be given a liberal interpretation. And we'd also like to add that there was a recent government notification from the Ministry of Commerce and Industry, which states that the current regime is well equipped to include AI works within its ambit. I'll just read out the title of the notification. The notification is titled, Existing IPR Regime Well Equipped to Protect AI-Generated Works, No Need to Create a Separate Category of Rights. And this notification was posted on 9th February 2024, last year, which reflects the government's intention to bring AI works under the current copyright regime.
But you have read that PIB press release selectively.
Yes.
It said the AI is covered under copyright, current provisions of the Copyright Act, but it also says that if the user wants to use the product for commercial purpose, it should take the permission if it does not fall under section 52 of fair dealing.
So we do think that Dhwani falls under the doctrine of fair use, and it's not an infringing copy because it is original, it is fixed in a tangible medium, and it aligns with the idea expression dichotomy. And it also satisfies the four-factor test. If the court may look to the US Court for guidance, they had laid down the four-factor fair use test in the case of Campbell versus Akufro's music. So if your honors would like, I would like to establish why it satisfies those factors.
Whether you will be resting on this notification also? The notification of the government, you are relying upon this?
Yes, again, it's
Whether this notification is having any binding effect?
No, it would not have any binding effect. It would only signify the intention of the government.
This is only intention of the government that if the other things are fulfilled, then probably it can be done.
Sir, it is actually a press release by PIB, and it is not a...
No, that this is what I'm just testing her on that only.
Press release arise out of the
Notification only, once notification is there, but this notification cannot go beyond the law or above the law.
Yes. But...
It's fine, it's fine.
Okay. Even though there is no...
5 more minutes extra to what, because we have raised so many
Just
questions.
let her
Because they hear the-
let her continue.
But,
जब दिखाएगा तब देखेंगे. Let him.
So, since there is no clear guidelines present and there's no new law to deal with this.
Again, persuasive value.
Yes. But through our arguments, we would like to establish why the current framework is sufficient. So even though the notification only reflects the intention to, we would like to argue as to why the current framework is sufficient to protect
Alright.
AI works. Yes. So Dhwani, in this case, the musical work, it qualifies as a musical work under Section 2P, and it's a derivative work under the meaning of the Act. And derivative works, as your honors would know, are copyrightable under the Act. The drafters of the Copyright Act of Indiana 1957 intended derivative works to be covered under the framework of the Act. And because Dhwani is a derivative work, it was derived from 4 existing tracks, it would be a derivative work, and those are copyrightable under the current Act. Secondly,
Don't you think that it will create chaos? Anyone can come forward and small changes in the original work, and then he will say this is the derivative work and register me also.
I understand your honor's apprehension about that, but it's not just mere skill, labor, and effort that is involved in this case. We believe that the petitioners and Amit's skill, judgment, and creativity, as I had explained earlier, qualify the threshold of originality that is required, and that's why it merits copyright protection. Any other work which doesn't satisfy or qualify that standard would not get copyright protection. But the facts of the case are such that it does meet that threshold.
All right.
Thank you, Your Honor. Your Honors, apart from the existing copyright regime being able to accommodate AI works, we have seen that international treaties and jurisprudence have also recognized AI-generated works as copyrightable. Apart from the Lee versus Liu case and the recent single piece of American cheese that I had stated, we also have the Painter case in the European Union, which is the landmark judgment wherein the court said that increasing advancements in technology are enough to signify that when technical aid is employed by an individual to its use, such creations will still be protected. So they are open to giving copyright to works where technological aid has been used in creating it. And a more concrete example would be the UK. In the United Kingdom, there's this act titled the Copyright Designs and Patents Act of 1988, the CDPA Act. And that act says that for computer-generated work, under Section 178, those works generated by computers in circumstances such that there is no human author of the work can also get copyright protection. So the UK is open to giving copyright protection for works where there is no human author at all.
We don't have such law. So
We don't as of now, but the definition of author, I would like to explain why it can accommodate AI works. So we, again, as stated earlier, we believe that the definition of author should be given a liberal interpretation, especially since there is no mention of human anywhere under Section 2D under the definitions. It doesn't say that there needs to be a human author, human involvement under the section itself. Apart from that, it doesn't exclude AI as being authors. Moreover, in this particular case, it's a musical work that we're talking about, and the author of a musical work would be a composer under Section 2D2, which states that in relation to a musical work, the composer is the author. And the composer is not elaborated on again, it's not defined. So it can be accommodated there as well.
But here the fact says that AI is not only the author. Author is Tayyab Raja
Yes,
along with AI.
yes, Your Honor.
So there is no individuality to the artificial intelligence.
No, the sole,
Amit.
yes, Your Honor. So the sole authorship,
You can continue for 5 more minutes.
okay. So sole authorship was applied for before the Registrar of Copyrights by the petitioner, but that was rejected. And the petitioner had revised the application to name both the petitioner himself, Tayyab Raza, as well as the AI tool, Amit, as the co-authors of Dhwani, and that was accepted by the registrar.
No, but whether it is not contrary to the facts which you made in first application.
Yes, it would be, but it has come to light that there's plenty of foreign jurisprudence that.
A false statement in first application.
Yeah. But right now we would be asking, we would be defending the position of co-author that the AI tool has with the petitioner. And other reasons why we believe that the AI can be considered as a co-author is because it can be granted natural and legal personhood. This may sound a little iffy, but I will explain. We think that the natural personhood of AI and humans can be equated to each other because AI, in this case at least, it possesses key attributes which would be akin to human creativity. It is able to display creativity, unpredictability, autonomy, rationality, and it's able to create an original work just like a human could. So it possesses human-like attributes.
Probably
And-
more than that. AI can be more powerful than the original
Yes, Your
one.
Honor, in some instances it can be.
Right.
And in this particular instance, the primary creative process lies with the AI tool, Amit, and it's able to autonomously integrate the execution as well. So the arrangement of musical elements, whatever is going in, is produced by the AI. So, and since copyright protects the expression of things and not the idea itself, we believe that the expression dhwani should be given copyright. Apart from its personhood being equated to a human, a natural personhood, we think that it can be afforded the status of legal person as well. Because legal personhood has been extended to non-human entities clearly, like corporations and other entities. So, and non-biological entities, that too. For example, in the case of Mohammed Salim versus state of Uttarakhand, the rivers Ganga and Yamuna were given
That
legal
judgment
personhood.
has been overruled or it is still pending? That judgment has become final?
It had,
No,
It-
up to the High Court, yes.
yes,
But later on, after it has been challenged in the Supreme Court.
it has
So
been.
what happened there?
The legal personhood status was not given. I'm forgetting right now.
You can always cite that any Hindu ideal that has been in the civil law, that is the best. That is the best thing.
Legal personality.
Legal personality.
Yes.
We always file a civil suit.
Yes. So the grounds of
How Raja can apply for Amit, for his author or what you term it, how he can apply
On his behalf, on AI's behalf.
on AI's view.
on his behalf, how, what right he is having.
Tayyab Raza, how can, question is, Tayyab Raza, how can he apply for this copyright?
Amit,
waiver of
for Amit.
So because these share co-authorship status and let's say rights like moral rights which are attached to copyright can't really be exercised by AI. So the petitioner, the human author can exercise it on the AI's behalf.
Whether that Amit has given any authority,
I mean, as a non-human entity, he does not have any authority.
But
Your Honor.
suppose Amit is granted this copyright.
Yes, Your Honor.
And there's a violation of that copyright. Who will file the case on behalf of Amit?
The petitioner would have to file.
why?
Who will be the petitioner there?
Whe-
Right?
Whether Tayyab Raja is ready to face the consequences of this theft, etc., or copyright act later on.
I mean, I think the facts would say that he is because he
That-
applied for sole authorship.
That is
first.
why he has
AI.
applied, basically. He has applied to save himself from those things.
That may be.
Was acting smartly.
Yes. Okay, anyways, you continue in your own way.
Yes. Just to, Your Honor had pointed out that the Mohammed Salim versus state of Uttarakhand was overruled when it went to Supreme Court. But over there, we believe that the grounds of revocation don't apply over here because they were concerned about who is going to, let's say, sue on behalf of these rivers, Ganga and Yamuna, or who's going to undertake the rights and liabilities under the law. So over here, just like we discussed moments ago, we think that the petitioner could undertake those liabilities now that he is the co-author. And just to give a few more examples why AI can be...
Your time is going to be up,
Okay.
so hurry up.
Yes, Your Honor. AI can be granted the status of a legal person. An example we would like to give is Saudi Arabia granting citizenship to the robot Sophia in 2017. So countries worldwide have been starting to recognize the AI as even a legal person, which means it could be potentially able to undertake rights and liabilities in the future. And just given technological advancements and how we should move forward, and there's several countries which we can look towards for jurisprudence. So because of these reasons, we put forth the case that AI work should get copyright, AI should be given the status of a co-author, and that the doctrine of originality is not disturbed in the process. With this, I would like to rest my submissions on issues 1 to 3. My co-counsel number 2 will continue with the remaining issues.
Thank you.
Thank you, Your Honors. It was an honor to argue before this bench.
Very intelligent to seek better relief.
Well done, counsel.
Thank you, Your Honor.
Yes, other speakers?
A very good afternoon to the honorable bench. Your lordships, I'm going to argue with respect to issues 4, 5 and 6, which are pertaining to the Competition Act and data privacy laws in India. So I would like to first begin my argument with the data privacy laws, if that is fine with the court. So, Your Honor, the security breach committed by the respondent raises privacy concerns under the Digital Personal Data Protection Act of 2023. So to begin with, the security breach which has been constitutes a personal data breach under Section 2U of the DPDPA by virtue of its confidential nature and ability to identify to whom it belongs to. The confidential user data of the petitioner and others constitute personal data under Section 2T of the DPDPA. Section 2T defines personal data as any data about an individual who is identifiable by or in relation to such data. Out of the aforementioned types of data, data relating to licensing agreements and user interactions with Amit will definitely allow a person with access to such data to identify the data to whom the individual belongs to. Since the data is personal data under the DPDPA, the breach of this data due to the actions of the respondent resulted in a personal data breach within the meaning of personal data breach under Section 2U of the DPDPA. Now, for further clarity, Your Honors, Section 2U defines personal data breach as any unauthorized processing of personal data or accidental disclosure, sharing, acquisition, use, alteration, or destruction of personal data that compromises the confidentiality of personal data which is available. This situation here would classify as an accidental disclosure of sharing of personal data that and the facts of the case support that the RoboMusic had exposed confidential user data and had hence compromised the integrity of the petitioners in the case.
1 minute.
Yes, Your Honor.
You have filed this appeal against the order of the enclave. You filed a case before CCI
Yes, sir.
under the Competition Act, right? And enclave said that there is no violation. You have come up in the Supreme Court against that order, right? So how this breach under DPDP Act is relevant for your appeal?
Your Honor, as my co-counsel
Very
had
honorable question.
Your Honor, as my co-counsel had mentioned earlier, while we agree that we have going against the NCLAT order and also the CCI orders with respect to the competition law issues, in today's day and age, along with AI and copyrightability, data privacy laws are also extremely important in our country, and considering the nature of the violation which is done. And
Question is whether once the finding has come by the enclave that there is no violation of this provision, then how you will argue this? Question is this: how you will argue against Robomed on this?
Your Honor, if you could just give me about 2 minutes, I'm gonna-
Yes, yes, yes.
Okay, so
Okay.
so the council would first like to emphasize the importance of privacy concerns which violate fundamental rights of the citizens of India under Article 21 of the Constitution, which speaks about the right of privacy. So in the case of K.S. Puttaswamy versus Union of India, this court observed that knowledge about a person gives power over the person. That personal data collected is capable of affecting representation, influencing decision-making processes, and shaping behavior. It can be used as a tool to exercise control over us and can leave with a satisfying effect on the expression of dissent and difference of opinion, which no democracy can afford. More
Whether the knowledge of AI can be considered as his personal original knowledge?
No, Your Honor, it cannot, and that is why we are saying that it is very important to
Then
have.
how you are arguing on this Article 21?
Article 21 protects the right to privacy, my honor, and more,
Privacy of what?
for example, in this case, a user, Tay Braza, so his data has been exposed due to the breach by the company. They did not have enough security to prevent a cyber attack, and more importantly, even if we leave alone Article 21 for a minute and just look at contract law, for example, this was a licensing agreement between my party and Robo Music. Every contract has a boilerplate clause of confidentiality, which states that the confidential information of the user will not be breached. More importantly, Section 2I of the DPDPA Act defines a data fiduciary as any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. The respondent has access to data related to user interactions, music preferences, licensing agreements, and music compositions for the purpose of creating music soundtracks. Moreover, Your Honor,
You see,
yes, sir.
if there's a breach of data, is it the absolute liability of this respondent?
Yes.
Or is there any exception when the respondent, even if there is a breach, can escape from the liability?
Your Honor, so I would like to bring your mention to Section 2U of the DPDPA, which defines a personal data breach, which includes even if there's an accidental disclosure of data breach to the public. And India, as a jurisdiction, has swayed.
Listen, suppose there
Yes.
is some cyber attack due to which that leakage of data is there.
Yes, sir.
In that situation, whether the person who's maintaining that data will be liable?
Yes, Your Honor, the person will be liable.
Even in a cyber attack,
Yes, Your Honor,
he has
and
taken all the precautions to safeguard cyber security and everything. In spite of that, there is a breach of data. And that breach of data is because of cyber attack by third party.
yes.
In
So,
that situation, whether there will be liability of the respondent here?
Your Honor, it would obviously depend on the facts of each case, but here we believe that Robo Music has not complied with every security.
There's nowhere in the facts.
So it's nowhere in the facts that they have also complied with the various security needed, because the cyber.
It is presumed, a person who is maintaining any kind of software or any kind of server, maintaining that security measures, it is always presumed.
Your Honor, so I would like to say two things. Firstly, I agree with your point that they might have had certain security measures, but cyber attacks in today's digital age are so common that it is happening almost on a daily basis. Firstly. Secondly, under Section 32 of the DPDPA, it is voluntarily to be mentioned by the company that there has been a data breach, and they go to the data protection board, which is something which the company has not complied with. More importantly, sir,
Kindly,
Proceed further.
I just want to know about Section 32. Where is this, where we can read
Your
this?
Honor, 1 second. I have the DPDPA.
But I have been given this, I could not find here. This notification, gazette notification, Section 32 is something else. Display of license, nothing else. The Act DPDA, DPDP.
Your Honor, I'm so sorry, I was referring to section 26, 28
Yes.
of the Act.
Okay.
Where procedure to be followed by the board. So right from sections 18 to sections 28, these following sections talk about the power of a data protection board, and it is also mentioned in this where
Where is this, counsel, please? Page, which page, which, where is this
yeah.
notification?
14, 14 page. So 14 page.
Your Honor, so
There is
section
no 28, page 20. देना इन्हें दो.
तो एक ही आपके में कम से कम होगा. ये तुमसे जो हो गया कहीं को 10 बोल हो गया.
so section 27 and 28.
I don't find anything in my copy.
So I can show you my copy if that's needed. 27
It is
and
supposed to be
28.
considered notification then.
नहीं गलती हमारे स्टाफ की है.
So I could read it out if you would like me to.
Please.
Section 27.
Yes.
Yeah.
Yes.
So section 27 talks about powers, functions, and procedure to be followed by the board.
Yes.
So on receipt of an information or personal data breach under subsection 6 of section 8, to direct any urgent remedial or mitigation measures in personal data breach and to inquire into such personal data breach and impose penalty as provided by the Act, or on complaint made by a data principal in respect to a personal data breach or a breach in observance by a data fiduciary, that is robo-music in this
So
case.
where from you are getting this presumption of data breach by robo?
Your Honor, this
This is the board's power wherever such case happens.
Your
such
Honor,
breach
but
happens.
it is the duty of the data fiduciary to inform that there has been a breach of data, which was, in our humble opinion, not done in this case.
Where it is that it is the duty of the fiduciary?
Your Honor, section
Some other section, kindly.
27(1)(b).
1. On receipt of an intimation. This says on receipt of an intimation. But where is the duty of the fiduciary to give the information or intimation?
Your Honor,
You have argued, you have started your argument with the fact that it was their duty to give intimation of their breach or violation to the board. Where is that?
Your Honor, subsection B.
These are all these things. This is a procedure only.
And in addition to that, I would like to add, suppose there is breach of fiduciary duty,
Yes, Your
then
Honor.
how it will help your case?
Your Honor, I would like, since considering that the DPDPA has recently come into effect in 2023, there was a similar situation which had taken place in the United States as well, where they, one second. Yes, Your Honor, so in the Yahoo case, for example, or the Equifax data breach case, or the case in Moot, where there was breach of millions of consumers' data, even in those precedents, there was cyber attacks which were done, and the US Supreme Court held that it is the duty of the data fiduciary to make sure that there are enough security measures to prevent such cyber attacks, because in today's digital age, we cannot afford to have such attacks. More importantly, they charge the respective companies such as Equifax over
Which is the legislation in US which you are referring to?
Your Honor, I'm referring to their data protection laws. I'm not sure which act, because the two cases are mentioned from a different timeline. I'm referring to the data protection laws though.
Of which country?
The
US or
United
India?
States, sir.
US or India?
US, sir. With
But you are holding copy of the Indian legislation.
Your Honor, there are no such landmark cases in the DPDPA as of now. That is why I am referring to the US law, because similar cyber attacks had taken place there, and then they had laid down the judgment for the threshold for cyber attacks and data breach in general.
No, is it a case of cyber attack?
Yes, Your Honor.
But you have not mentioned anywhere so far.
Your Honor, this is a case of cyber attack. And
Mr. Counsel, you know that you have gone to the Supreme Court mainly for one reason, that against the judgment of the NCLT, okay, that by which the decision was given against you, right? So you are not talking about the anti-competitive, the practice on the basis of which NCLT has decided your case, and on what basis you are making the this SLP to the Supreme Court relating to this point. This is the major point here.
Your Honor, I understand your
I
apprehension
am talking of Section 3, subsection 5
of the
of the
Competition Act.
Competition Act.
Your Honor, I will be coming to that after this. But with respect to your concern,
By
which
that time your time will be over.
okay, Your Honor, then we can move on to section.
That is the crux of your case.
Their arguments are divided in two parts.
Yes, yes.
Which
That's
is
the crux of the case.
Here,
3-5 is
one
the crux of
counsel
the
is
case.
not arguing the
One
entire
counsel
argument.
should argue
Okay, Your
as
Honor,
a
I will
whole.
speak about section 351, which is a primary concern. So the restrictions in RoboMusic's licensing agreement cannot be justified under the intellectual property exemption in section 3.5 of the Competition Act 2002.
Council section 8(6), section 8 subsection 6 clearly lays down that in the event of a personal data breach, the data fiduciary shall give the board and each affected data principal intimation of such breach in such form and manner as may be prescribed.
So there are rules.
So this is what I was asking you.
Yes, Your Honor. I'm sorry.
No, it's fine, it's fine. Continue.
Firstly, there is no there's no necessity for RoboMusic to foreclose the market and create unreasonable barriers to entry as per section 3.5 of the Act. So in the present context, RoboMusic's restrictions appear to go beyond what is reasonably necessary to protect its IPR instead of functioning as a tool to stifle competition. So section 3.5 of the Competition Act envisages that nothing contained in section 3 prohibiting anti-competitive agreements under section 3.4 shall restrict the right of any person to prevent infringement or imposing of reasonable conditions that may be necessary for protecting his or her intellectual property rights, that is copyright, trademark, patent, designs and geographical indications. The question as to whether imposed under the agreement is reasonable or not would be a matter which would only be decided by the CCI under the Act. So the Competition Commission of India's booklet on the IPR exemptions states how forcing licenses to acquire particular tools solely from the patentee, thus foreclosing the opportunities of other producers, cannot fall under the IPR exemption, nor does the same apply for exclusive licensing agreements. This is there on the advocacy booklet which is uploaded on the website, and more importantly, Your Honor, it also states how a clause in the license agreement which restricts competition in research and development or prohibits a licensee from using rival technology is anti-competitive and is so restricting it to a category of customers.
Are you aware of few judgments which have been delivered by Delhi High Court, like Ericsson,
Yes, sir, I'm aware of Ericsson.
like JCB, like Monsanto?
Monsanto, yes, sir.
So where these IPR laws have been given primacy and the proceedings of the CCI were quashed, two of them are pending before the
Supreme Court, yes, sir.
One has been decided by even Supreme Court. They agreed with the Delhi High Court's verdict. In light of those judgments, how will you argue your case?
Your Honor, so I'm aware of the case of Ericsson and also JCB. I'm not quite sure of the third case, but I would like to bring your attention to a very similar case which was decided by the CCI and later on upheld in MSHT Media versus Super Cassettes. Super Cassettes limited the choice of music for the end consumers to only the music content of Super Cassettes. They had licensing agreements where they would charge excessive amounts as licensee fees or royalty from radio operators for grant of rights for the broadcast of its music content. The CCI held that this was exploitative in nature since the radio channels were being asked to pay for music it may not play. The CCI held the practice to be exclusionary in nature, and they also said that the agreement should be modified. Your Honor, we spoke about Ericsson and also JCB. I would like to bring it to your notice that the court in those cases spoke about the test of reasonableness and necessity.
Now, one more issue was there. It was held in JCB when the dispute was pending before Delhi High Court regarding the infringement of copyright. Then CCI had no jurisdiction to step in unless that dispute was decided by the Delhi High Court. And this JCB case, the ruling of the Delhi High Court has been upheld by Supreme Court, and the appeal filed by the CCI was dismissed. So, and now you are talking about the ST Media case, which has been decided by the CCI and is still pending before NCLAT. So, how this decision will override the judgment of the Supreme Court and High Court?
Your Honor, I would like to bring it to your notice that the facts of this case are somehow a little different, because if we want to talk about a higher authority than the CCI, we can also talk about the Shamsher Kataria case, which laid down the test of necessity and reasonableness. Your Honor, in the current case, Robo Music does not have the necessity to have such licensing agreements, as we are not talking about a particular drug in the market or any medicine which is extremely needed for the society in general. This is an AI music agreement, and so more importantly, let's just use the example of ChatGPT, that is OpenAI. Now, if they start having such licensing agreements with members of the public, it will just hamper innovation and creativity, and it does more harm than it does good.
So your work will be innovation, and if I want to do it, that will be some kind of breach.
Your Honor, I would...
So license, there should not be any restriction. In your case, there should not be any restrictions, just are unjustified, and in my case, they will be justified.
Yes, Your Honor, there is no necessity to have such restriction.
This is what I say.
Okay, sir. So,
You are pleading that this was an anti-competitive practice.
yes, Your Honor.
Adopted by the respondent. On what basis? Was the terms laid down in the licensing agreement one unreasonable? Because reasonable test is there, reasonable conditions. This is the expression used in section 3.5. So how will you prove that this 3.5, that there is a violation of 3.5 by laying down some conditions which are unreasonable?
Your Honor, I would like to bring it to your notice of Guideline 74 of the vertical restraints of the European Union. And the guidelines on vertical restraints have not only been used by the CCI but have been used by the Supreme Court for jurisprudence. They have clearly stated in their guidelines, which is also in consonance with the CCI advocacy booklet, that pure licensing agreements do not fall under the exempt of intellectual property right. Moreover, the landmark case of McGill, which has shaped competition law jurisprudence, has opined in the conditions in which refusal to grant a license may result in abuse. Firstly, if such refusal prevents the appearance of new product which has potential consumer demand, which is music in this.
That's fine.
Yes, Your Honor.
How will you go for the test of reasonableness? In your case, how will you say that this was unreasonable? Because you are pleading on that basis is unreasonable, therefore it is an anti-competitive.
Your Honor, I would like to bring about an Indian jurisprudence which spoke about the test of reasonableness and then see how it applies here. So there is a case of Multiplex Association of India versus the United Producers or Distributors Forum.
I'm not asking for the distinction between reasonable, what is reasonable, what is unreasonable. I'm not asking. I'm asking on the basis of the facts of this case.
Okay.
How can we say it was unreasonable? The licensing agreement was providing some unreasonable conditions.
Okay, sir.
This is a simple question.
Okay, so it is evident from precedents and various guidelines that here this is just not a form of, it is a form of commercial exploitation which has been done by their artificial intelligence, and I will tell you how. The entire market has been foreclosed as nobody can use their AI for their own use until they have a licensing agreement alternative contractual safeguards out here, such as limited licensing rights, or maybe charging a subscription fee or a royalty for using the license could be done. More importantly, the licensing clause faces the reasonably and necessity test because it is extremely redundant to use the claim that such music is essential in any sense and needs safeguarding that is not, because it is not even an essential patent. Like if we talk about reasonableness, we can see from precedent that there are various drugs, there are various medicines and things which are needed for society which have spent decades in developing and are thus given any exemption because of the amount of capital and needed, and that's how copyright works.
Counsel, the condition which was imposed in this licensing agreement was that you will not go for the copyright registration in case this what is its name, Dhwani.
Dhwani, yes.
Dhwani generates some work, right? So what it was, the condition was, it was asking you not to commercially exploit that work, the software which was created by RoboMusic. And you are arguing something else. So you have to argue that this condition is not reasonable. Firstly, it was not necessary. And even if it was necessary, it is not reasonable. So you have to satisfy these two tests.
Okay, Your Honor, so
So your time is going to be up. Kindly sum up whatever you want to say. No, that is why I say it has to be somewhere. The time is going to be up.
okay, Your Honor, so the
You answer this question and then thereafter you sum up.
okay, Your Honor, RoboMusic has absolutely no rationale on denying the software they have built for all users. There is no necessity to protect such a thing, because if you use this, then if you set a precedent today that such a licensing agreement was necessary, then every company would come under the ambit of Section 3(5) of the Act and claim exemption. So for the test of reasonableness, like I mentioned before, I would like to just cite the Microsoft case, which is a very well-known case in jurisprudence. AI allowing the production of a new product which has absolute demand in the market cannot be hindered by using any agreement such as a licensing agreement because of the consumer demand. If there is consumer demand in this case, which is there, because as we know that the music industry is booming so much, if we have a licensing agreement or a restrictive clause, and the CCI has clearly stated in the case of Atos Worldline India Private Limited that having such restrictive clauses in agreements are done by many entities to use such exemptions under Section 3(5) of the IPR. There are so many companies which have come to the commission itself and have tried using Section 3(5) to get away from their various obligations they're supposed to. This way we can just grant every company a licensing agreement which will have a clause for exclusive dealing. And it is also to be noted that in this case, RoboMusic is a dominant entity under Section 4 of the Competition Act.
How do you say it is a dominant entity?
Your Honor, if you could just give me 2 minutes, I would like to sum up and explain.
Already granted 2 minutes.
Okay, so Your Honor, RoboMusic has abused his dominant position.
No, this is a second stage.
Yes, sir.
How do you
Okay.
say it is
It is a dominant entity. Okay, I'll get to that first.
And abuse, by the way, is covered under Section 4, not under Section 3.
So yes, sir, Section 4, dominance. I mentioned. Okay, so there are two parameters to determine dominance under Section 4 of the Act, which are whether they operate independently of the competitive forces prevailing in the relevant market and whether it affects its competitors or consumer, making the relevant market in its favor. So in the DLF case, which is a landmark judgment, the Commission enunciated on stating how in a competitive scenario where the enterprise indulges in anti-consumer conduct, there is sufficient competition in the market to provide easy alternatives for the consumer. Here, DLF was able to influence both supply and demand of projects in the relevant market. Your,
The case is not relevant.
You filed a case before CCI under section 3.
Yes, Your Honor.
CCI passed order, found violation that was overturned by NCLAT under section 3.
Yes, Your Honor.
Now you are arguing under section 4 before the Supreme Court. How?
Your Honor, so
What authority you have to argue even?
Your Honor, so I also have an argument for Section 3, when in most cases which are decided by the Commission, Section 3 and Section 4 go in consonance. Section 3(4) discusses anti-competitive agreements, and in most scenarios where companies have engaged in anti-competitive behavior, they were in a dominant position to conduct such behavior. In the current case, Robo Music is enjoying a market with no competitive forces, where there are other AI options for people like Tire Braza, or they would have gone to such places. The music is more or less constrained by Robo Music, who are doing such an act in the market. If other competitors were doing the same, Robo Music would have not had such exclusive license agreements, which proves that they are a dominant entity.
But Tayab Raja will be saying something when he gets some kind of license under the Copyright Act or something. His rights are protected. Otherwise, unless he gets recognition, how you are saying that this is going to be done?
Your Honor, I am trying to tell you how Robo Music is being a dominant entity, because their entire music subscription model is either take it or leave it. And as we know, Section 3(4)(b) of the Competition Act clearly prohibits exclusive dealing to take place between a company and the consumer. So,
Exclusive dealing, that is okay. That is entirely different. You are coming to a second stage. First, you are not satisfied how you are able to prove that it's a dominant undertaking or it's a dominant entity. How do you?
What is your ground to say that?
Was it having some kind of such a huge share in the market, or were they in a position to dictate their terms to the competitors?
Your Honor, that...
Simple, this is what the dominance under the
Okay,
Act.
Your Honor, just 30 seconds and I will explain this to you.
Please,
So,
please.
while market share is the primary factor for dominance, which I completely agree with, since market share is not mentioned in this case, we will go towards the other indices. So, in the CCI's case of updated terms of service and privacy for WhatsApp, they stated WhatsApp to be dominant in the relevant market for over-the-top messaging apps through smartphones in India on the basis that WhatsApp's pronounced networks made it difficult for the consumers to switch apps and force,
Correct.
Yes.
WhatsApp is the correct case.
and there was
That is
dependence.
That is rightly decided.
Yes,
Because it is prima facie that WhatsApp is dominant.
yes, Your Honor.
Where are the options? The question, the dominance, if you look at section 4, what section 4 says about dominance? That you are in a position to overcome your competitors. This is what primarily the
Yes, Your Honor, I
section
agree.
4 provides. So my question is, how you are able to say that this Robo Music, or whatever is named, Respondent, was in a position to dominate over the other competitors? It's a simple question.
Your Honor, this can easily be implied by the mere fact that they had such exclusive licensing. And so, if I remember, I told you in the beginning that they can have restrictions by which allow them to operate independently in the market. So, DLF case, I'll tell you why it's relevant in this scenario. DLF had also engaged in conduct which could make them survive in the market by having certain conditions which were not competitive. In the current situation, Robo Music enjoys a first mover advantage in AI generated music service, that it is a very well known platform like WhatsApp was or even Google was, and they have explained, like, if you have an agreement, like an exclusive licensing agreement, it means you are dominant in the market because they are operating independently of what other competitors were doing. Your Lordship, if let's say Robo Music, let's take an example. Let's say that ChatGPT has a platform for creating music. Similarly, how Robo Music does. Robo Music would never be in a situation to have such exclusive licensing agreements if ChatGPT was a competitor. They are operating independently of the competitive forces.
But you are not even a competitor so far. You have not been granted any patent right.
Sir, the example is given that Google. Everybody knows Google is dominant.
That's right.
Prima facie, it's dominant.
Okay.
And
It's fine, no, finish it.
Your
Finish it.
How
Honor,
it is dominant? This
Your Honor, we
respondent is
are-
dominant. That is the precise question.
You finish it now. Oh, that's right, that's right.
Your Honor,
Leaning on that.
Your Honor, it is mentioned in the facts of the case how the commission imposed a 5 crore fine on Robo Music, finding that restrictive conditions distorted competition by limiting users' rights to assert control over AI generated works. There is no other key AI player which is mentioned in the market, and this can easily be proven by the fact that if there was any other key player, Robo Music would not be in such a position. The relevant market in this scenario is not AI. The relevant market is AI in the music industry for producing music.
On what basis and collect that reverse this case?
So NCLAT, they do not refer to the CCI's advocacy booklet, I feel.
Okay, please sum up.
Okay, Your Honor.
Already sum up, sir. These were extra. Okay, finished.
Okay, just to conclude, Robo Music benefits from pronounced networks. It makes it difficult for artists to switch platforms. Since users cannot claim copyright over AI generated works on Robo Music, they are locked into their ecosystem. Even if a competitor offers better licensing terms, switching is costly because users would lose access to prior AI compositions, which is evident in this case. It is evident that they are abusing their dominant position as they are controlling people like Tayyab Raza, and more importantly leveraging their dominant position in a field like artificial intelligence, which restricts the flow of music fundamentally in today's date. So I'll just say the prayer and then.
Yes. We know your prayer. Already we are fully aware of
Okay,
it.
sir, then. Thank you so much, Your Honor. It was a pleasure arguing in front of you.
Despite all grilling,
Yes.
you stood with your ground.
Well done, counsel.
You stood with your ground.
Willing.
Yes, the other side.
Council seeks the permission to approach the dais.
अभी पता चल गया.
Council solicits the permission to begin.
Yes.
Greetings to the honorable bench. If it may please, the council seeks the permission to address the bench collectively as my lords. Much obliged, my lords. My lords, the council is here appearing before the honorable bench in the case of Tayyab Raza versus Robo Music Private Limited on the behalf of the respondent. If the bench is well versed with the facts of the case, the council wants to proceed with the pleadings. Much obliged, my lords. My lords, the current case have 4 issues. The council would be dealing with the first and second issue, and the co-council would be dealing with the third and fourth issue. My lords, the first issue is that, can the Copyright Act of 1957 protect AI-generated works such as musical notations created by AMIT and
Counsel, are you not disputing about the filing of this SLP under 136? I'm not disputing that.
certain...
Why SLP, why not it should be an appeal under the Competition Act, because primarily the case is against the Competition Commission.
My lords, council bows down to the wisdom of the honorable court. However, sticking strictly to the proposition of the case, the petitioner has approached the honorable Supreme Court against the appeal, in an appeal against the final decision of the National Company Law Appellate Tribunal, and the case contains substantial question of law, which must be dealt under Article 136 of the Constitution of Indiana. My lords, the first issue is, can AI system like AMIT be recognized as author or co-author under the Act, and does the AI generated work be protected under the moral right provisions of the Act? And the council would be establishing this issue by 4-pronged arguments. With the due permission of the bench, council would like to proceed with the first prong of the argument.
Yes.
Much obliged, my lords. My lords, the Copyright Act 1957 does not recognize AI as either author or co-author. AI is excluded by the Copyright Act and is not accommodated by it. My lords, the Indian Copyright Act defines copyright as a statutory right rather than an innate right or a natural right, as per Article 16 of the Act. My lords, all the right as per Article 16 regarding copyright are to be interpreted from the Copyright Act. And only those persons who come under the definition of the author mentioned in the Copyright Act are given protection under the Copyright Act. And Section 2, subsection D, subsection 6 of the Copyright Act states that author means the person
You
who...
were saying Article 16.
Certainly, my lords.
So where is that? Certainly, it's section, not article.
Council apologizes.
Copyright Act.
Section 16 of the Copyright Act.
Yes. Continue.
My lord, Section 2, subsection D, subsection 6 of the Copyright Act states that author means the person who causes the work to be done in relation to any literary, dramatic, or musical or artistic work that is computer generated. But artificial intelligence is not included in the definition of the person. If we talk about the General Clause Act also, in the Section 3, subsection 42 of General Clause Act, it defines person, and in it also artificial intelligence is not included. And if we talk about jurisprudence also, personality is divided into natural person and legal person.
When you say this General Clauses Act,
Yes, my lords.
this person, this definition is inclusive or exhaustive, or something is left? Can you read that definition here? You don't have.
Sir, my
You
lords.
have?
Yes, sir.
Can you give it to me? I just want to see whether it is exhaustive or
General Clauses Act, not General Clause Act.
General Clauses Act, section, whatever you have read this.
You were saying General Clause Act.
General Clauses Act. Where you are person, definition of person. You have just said, let me find out.
My lords, in the General Clauses Act, in Section 3, subsection 42, it defines person as any company or association or body of individuals, whether incorporated or not. So it does not make any mention of artificial intelligence in it. And therefore, it can be contended that artificial intelligence is excluded by the definition of the person. Furthermore, my lords, in the case of Cambrian Private Limited versus National Pencil Industry, it was held by the Honorable High Court of Delhi that copyright is conferred only upon those who are natural persons from whom the work has been originated. In the circumstances of that case, plaintiff could not claim any copyright in any carton that was mechanically produced by the printing process. And the same is being done here, my lords. In the present case at hand, the user, that is the Tayyib Raza, has did nothing. The role of the Tayyib Raza is very minimal, and there is no human intervention. And apart from that, AI is excluded from the Copyright Act, and therefore the work should not get copyright protection. Furthermore, my lords,
You are challenging about Raja, or you are challenging
Both,
about
both.
Amit.
He is saying both.
Amit has done something or not?
my lords, AMIT has autonomously created the artwork Dhwani, but AMIT cannot be considered as co-author or the author under the Act.
Because of the definition of this.
If we talk about the application for copyright registration, that is Form 14, it also requires disclosure of the claimant's name, nationality, and address, and which artificial intelligence lacks. And therefore, it can be contended that artificial intelligence is excluded from the Copyright Act 1957. My lords, the second prong of the argument is that Dhwani, the artwork here, has failed the test of originality, that is a sine qua non for a work to get copyright protection. My lords, in order to get copyright protection, a work must satisfy the criteria of the doctrine of originality. That is, work should be author's own intellectual creation and not a copied version of the existing work.
There is no such finding.
Pardon, my lords?
There is no such finding that it is not original, or this work is not original.
My lords, in the present case, the work does not fulfill the criteria of originality, and the council would be establishing this fact.
Yes, from where?
And I would like to add,
Yes, my lords.
derivative work is also recognized under Copyright Act. No?
My lords, if my lords refer para 57, page 31 of the Moot memorial, it was stated in the FIST publication case by the Honorable Court that mere rearrangement of information that is already available to public would not be called a creative work and lacks the creative effort by the author. And therefore, the work, that is the Dhwani here, is just a recombination of the 4 pre-existing soundtracks. And apart from that, my lords, as per para 2 of the Moot proposition, it states...
Suppose 4 ingredients are put in a mixie and they are grinded. A new thing will come out. And but all the 4 are there. All the 4 are there.
Certainly, my lord.
So it will not be a new thing.
Some original thing is created.
New original out of 4
Four.
ingredients, new 5th has been created, whether that can't be registered.
My lords, although it can be a fact that new thing has been created, but from the various precedents of the courts, it is stated by the courts that there should be the work should be intellectual creation of the author.
That is not mixing 4 is not intellectual. A person taking
That is-
decision 25%, 20%, some good is.
Ayurveda medicine,
But my lords, here the
it's IPR also.
My lords, in the present case, the recombination process is done by AMIT and not by the petitioner Tayyib Raza here.
No, but the composition which has been made, it was the
AMI,
Tayyab Raja.
Tayyib Raja only. Amit has come into being or existence because of Tayyib Raja.
It is only for the purpose of creating that thing on that software. But the efforts of Tayyab Raja, the efforts of the appellant were there to create a new thing.
My lords, in the Moot proposition, it is specifically mentioned that the software autonomously generated the unique composition with minimal human intervention.
Composition by whom?
But
With the efforts of
Tayyib Raja. Tayyib Raja.
My lords,
Tayyab Raja. The efforts were of Tayyab Raja.
the efforts were, the council,
Efforts means to put in something new.
Otherwise it has come from space, according to you?
my lords, the council begs to differ on the ground that Tayyib Raza had just the authority to give requirement that, yeah, I want this song and these things I want. But
Is it not involving some skill and some
intellectual,
intelligence and some intellectual?
taking this decision that he requires this.
my lords, but
If it is not an intellectual exercise, it may lead to some absurd results.
but the requirement does not meet the threshold of skill and judgment.
Counsel, kindly read the very first line of summary of facts. Tayyib Raja, an acclaimed electronic music composer from Delhi, Indiana, created a music composition titled Dhwani using Amit. He created this. This has not come into being on its own. Tayyib Raja was responsible for creating it with his minimal efforts.
My lo- yeah, my-
Continue.
My lords, furthermore, section 13 subsection 1 of the Copyright Act also states that work should be original, but it does not define it. Therefore, in the precedent of Eastern Book Company versus DB Modak, the Honorable Supreme Court established the standard of originality in which it stated that the copyrighted material is what is made by author's skill and judgment. But the council wants to contend that in the present case it is not the skill and judgment of Tayyib Raza, the petitioner here. Because in the para 2 of the Moot proposition, it is clearly mentioned that AMIT utilizes advanced AI algorithms to analyze a vast library of musical elements, and the software autonomously generates the unique composition and had the primary creative process. So it can be contended that, yeah, although the Tayyib Raza had the authority to shape the output, but the authority to shape the output does not meet the threshold for the skill and judgment. Like, I would give an example to my lords that if my researcher had made this memorial and write down all the arguments in it, and I just have the authority to write page number or adding header or footer on it, so it does not, it cannot be contended that I have used my skill and judgment in making the memorial. Likewise, Tayyib Raza only had the authority to customize the output, to shape the output to such extent, to give a finishing touch to the output. and therefore,
So, to the extent Tayyab Raja contributed in creation of this product, the his work can be copyrighted
no, my lords, the work cannot be
to the extent.
certainly not, my lords, because there was a significant level of AI involvement in the work.
So this memorandum is the effort of you or your teammate, or both?
It is a joint effort, my lords.
Then,
Then both have the right of registration or not, trademark registration, that both contributed.
AI cannot be considered as a co-author, as if sticking to the
so
act.
you have also only numbered the memorandum, nothing else. So how you are the creator? How you have done anything? So you, both of you have contributed. Maybe you have done 10%, the other one has done 90%. You both have done.
Yes, my lords.
What they have done, they have a right for registration up to that extent. But you made it extra for what you made it finally, that you have a right. They can't claim the full. They can claim that portion which they have drafted.
Certainly, my lords, but in the present
You
case,
made a new one. They can't say that you can't use. You can also use because you changed little bit.
my lords, but in this case, we both are natural persons, but in the present case at hand, it is AI, which is excluded.
That is correct. That has no legal personality,
Yes.
identity. And Raja can't claim that he can represent that Amit. That is correct.
So you should confine to your first argument.
So the
That copyright cannot be given to that by individual. He is not an individual. AI is not an individual.
Council is here to contend that the work cannot get copyright protection, as well as AI cannot be considered as author or co-author. And the whole work cannot get copyright protection, but because it does not meet the criteria of originality mentioned in the case of Eastern Book Company versus DB Modak.
Okay. Okay. Proceed.
The third prong of the argument is that, my lords, the present in the present case, the AI generated work, that is Dhwani here, cannot be protected by the moral right provisions of the Copyright Act also, because AI is excluded from the copyright law, and the work cannot get copyright protection, and this forms the basis that the work cannot get moral right provisions. Because in the case of Amarnath Sehgal versus Union of India, the court ruled that moral rights are inseparable from author's personality, rooted in their emotional and reputational bond with the work. But AI has to do nothing with the reputation and the emotions. It has nothing with mental capacity, it has nothing with mental ability, and therefore it can be contended that the work cannot be protected under the moral right provisions.
Moral rights under which provision of the Copyright Act you are talking?
My lord, section 57 of the Copyright Act.
Author's special right.
Pardon?
57 of the Copyright Act says author's special right.
57 of the Copyright Act regulates moral rights of the moral rights.
I'm just going to through it.
Author's special right.
Can you read the judgment, this definition for the benefit of the bench? 57, section 57.
My lords,
I'm having it.
basically the section 57, subsection 1, clause B clearly states that author of a work shall have the right to restrain or claim damages in respect of any distortion, mutilation, modification, or other act in relation to the said work. And exactly this is what moral rights states. A person possesses moral rights to protect his work from any kind of destruction, distortion, or any kind to prevent it from any kind of its negative use.
Where you are reading this moral rights?
Where is that section 57?
No, in 57, where you are saying this moral rights? I am reading 57, author's special rights.
Kindly read section 57.
You were reading clause B of subsection 1.
Yes, my
It
lord.
says, I will read as a whole, independently of the author's copyright, and even after the assignment either wholly or partially of the said copyright, the author of a work shall have the right, now I read clause B, to restrain or claim damages in respect of any distortion, mutilation, modification or other act in relation to the said work, if such distortion, mutilation, modification or other act would be prejudicial to his honor or reputation. Where is moral rights?
My
I have
lords,
failed to understand what kind of moral rights. That is why I was asking this.
it is not explicitly expressed in the Copyright Act about moral rights, but it is regulated by Section 57. Moral rights are regulated by Section 57.
Again, you're using a moral right that we are disputing.
Moral rights have any legal sanctity? What are the moral rights?
My lords, when
Morality is something which is probably no place for in law.
my lords, when a work gets copyright protection, the author of the work gets certain rights to protect the work from any type of distortion, destruction. The person gets the right to paternity, integrity to their work, and this.
You can't use the word moral right, but my.
You can say you should restrict yourself to the whatever is there, or a right, a legal right.
Not the moral right.
Whenever you are arguing before a court, you should ask about the legal rights.
Okay.
Moral right, court can't enforce moral right. Legal right we can enforce.
Okay.
Continue. This was only to just tell from our experience whatever is there.
Out.
The idea of having moot is only
But
this.
yeah, my
That
lords,
you should
but
know the niceties of practice.
moral rights are basically legal in nature. Moral rights are the meaning of moral right is that the work should be. It is moral to protect the work. It is morally
You
correct.
have to go by the act. You can't create your own provisions of law.
So, my lords, apart from the Act, if we talk about Article 6 bis of the Berne Convention, that the Indian Copyright Act has, from which Indian Copyright Act has taken much, it clearly states that authors should enjoy the right of paternity and integrity to their work.
You are right. We are not disputing what you are saying, but only dispute arose when you use the word moral.
So,
Anyways,
my lords, therefore, the AI has no emotion or reputational bond with the work, and therefore it can be contended that the AI cannot possess moral rights, and the AI generated work itself cannot possess moral rights.
let him.
My lords, it is the issue in itself, that whether AI generated work can possess moral rights or not.
Page 7.
The fourth and last prong of the issue 1 is that as the jurisprudence in Indiana on the aspects
Let
of
us read the issues raised where you are saying moral. You are joining the issue. Where is this issue raised? You have just said that there is an issue with regard to moral rights. Let us read. Where is that?
in the issue 1 of the moot proposition, in the second part, it is clearly
Where are the issues? Issues raised are at page 7 of the bench memorandum given to us.
issue 1 in the moot proposition.
Let us see. Where is that proposition? Moot proposition. This? Red one? No, it is their company. Moot proposition. Where is this? Yeah, it is in this book.
No, my lords. On the last page of it, where issues are stated. In the first issue, it is stated that can a Copyright Act protect AI generated work such as musical notation created by AMIT, and can AI generated work like Dhwani be protected under the moral right provisions of Copyright Act? Therefore, my lords, the council is contending the moral rights, and they are a part of Copyright Act.
You are right.
All right,
The
all right.
composure of this was wrong.
Fine, yes.
Much obliged, my lords. My lords, the fourth pronged argument is that as the jurisprudence in Indiana on the cases of AI, copyright, competition issues are evolving, the courts look forward to the international precedents and jurisprudence to have some for the persuasive value and to set a standard precedent. And in the case of COFEML versus G Star, my lords can refer the compendium on page 51, para 22. My lords, the compendium, wherein in the case of Cofemel versus G Star, Court of Justice of European Union held that subject matter must be results of author's own intellectual creation, and hereby, and in the present case at hand, the the intellectual creation of the author was not there, as the majority of the work was done by AMIT itself. And if the approach is taken by Australia and Thailand, currently lack sufficient protection for the work created by AI. So this states that in the international scenario, there are many jurisprudence and precedents that states that AI work cannot get copyright protection, or the AI cannot be recognized as author or co-author under the act.
But the other party argued that in China it has been done, in Canada it has been done.
My lords,
He will be using his own benefit cases. Why he will argue?
certainly, my lords, in the Lee versus Lu,
He is trying to persuade us whether we should take China route or the other country route. Question is this only.
in the case of Lee versus Lu, although the China court held that AI generated work can get copyright protection, but it specifically stated that the AI generated, the human involvement in that case must be considerable human involvement, wherein in the present case at hand, human involvement is equal to negligible.
Are you aware of the guidelines issued by US regarding this?
Which guidelines, my lords?
Guidance code, which clarifies that it is not necessary that the entire thing where some human contribution is there can be copyrighted. It can be copyrighted to the extent that person has contributed.
My lords, it is the case, but there are various, for a work to get copyright protection, it must satisfy the doctrine of originality. And there are various approaches for doctrine of originality, like skill and judgment test, like sweat of brow theory, like modicum of creativity theory, in which in all these judgments, the crux is that there should be a considerate level of skill, judgment, labor, diligence of the author in the composition of the artwork. Whereas in the present case at hand, there is a contribution of author is equal to negligible to zero.
On what basis you can say that the contribution of Tayyar Raza is equivalent to zero?
It is clearly stated in the proposition of the case, my lords. It
says minimal. It says minimal.
Minimal human intervention, and further it says that can adjust the parameters to customize the output only, but the creative process remains with AMIT. So here the complete game is of the creative process, my lords. To shape the output, to give a finishing touch to the output cannot be considered to have a skill and proper judgment in the case, in the composition of the artwork.
You sum up your time as.
Yes, my lords. The issue second is that introduction of AI challenges the doctrine of originality or not. So the council here contends that it does challenge the doctrine of originality, as the council had earlier contended in the arguments that there are three theories: skill and judgment theory, modicum of creativity theory, and sweat of brow theory, that regulate the doctrine of originality. In the skill and judgment theory, it was established in the case of EBC versus DB Modak, in which the Honorable Supreme Court held that copyrighted material is that which is created by author by his skill and judgment. In the sweat of brow theory, the Honorable Court held that more importance is given to how much labor and diligence it took to create a work rather than how original a work is. So in both these theories, it can be clearly contended that there was no such skill or diligence used by the author in the composition of the artwork Dhwani. Therefore, it can be contended that the work does not meet the criteria of the doctrine of originality.
All right.
My lords, the third and fourth issue will be dealt by the co-counsel.
Okay.
It was a pleasure for the
And fifth
council.
and sixth, who will argue?
My lords, the third issue is combination of fourth and sixth issue.
Combination.
Yeah.
The council seeks permission to approach the dais.
The council seeks permission to address the bench collectively as my lords. Much obliged, my lords. The council will be dealing with the issue 3rd and issue 4th before the bench. The issue 3rd is the merger of issue 4th and issue 6th in the moot proposition. The issue 3rd before the court is that does RoboMusic's licensing agreement that restricted from claiming copyright over the AI generated compositions constitute an anti-competitive behavior under section 3 of the act or not, and is it justifiable under intellectual property exemption under section 3 subsection 5 of the Competition Act. My lords, the RoboMusic's licensing agreement, which restricted users from claiming copyright, it does not constitute anti-competitive behavior under the Section 3 of the Competition Act, and the Council will be establishing this issue on the basis of two-pronged arguments. Continuing with the first-pronged argument, the licensing agreement is itself protected by the IPR exemption provided under Section 3, subsection 5. Intellectual property exemptions are given to certain agreements in order to protect the copyright of any particular subject matter, and in this present case, the agreement of the RoboMusic with Tayab must be granted protection under Section 3, subsection 5. Section 3, subsection 5, clause 1 allows reasonable restrictions that are necessary for protecting intellectual property rights such as copyrights, patents, trademarks, etc. And the exemption applies only if the restrictions directly protects the IPR in question and it does not unreasonably harm competition in the market. There must be a reasonable nexus to IPR protection, that is, to qualify for the exemption under the said section. The restriction must be proportionate to the need of protecting the IPR. And my lords, as per the facts of this case, the RoboMusic company has imposed certain restrictions with the intent to ensure that the underlying technology, specifically the training data that was fed into AI and the algorithms and the creative process of AMIT, it is not diluted or misappropriated. The restriction is narrowly focused or that prevented users from claiming copyright. It does not prevent users from using, distributing, or further creating any other AI-generated work. The key requirement to impose restrictions must be narrowly tailored to address the risk of IP misappropriation. And in this specific case, they can still innovate in the market, they can compete in the market. The restrictions are only clarifying that who will retain and who will have the authorship over the works that was created by the users itself.
Council, IPR are considered necessary for promoting innovation. And if the protection which has been provided under Section 3.5 of the Competition Act is not extended to the copyright holder or to the creator of that Amit, then how you will balance the requirement?
My lords, the protection must be extended, but it must be extended to an extent that the conditions imposed by the copyright holder, it must be first of all reasonable condition, and second, it must be necessary. There must be a necessity to protect the IPR to impose that condition. But in this case, there was a necessity because the necessity was to protect the intellectual core of the AMIT, the investment that the RoboMusic has put up in the AI to ensure that the algorithms or the data that was fed into AI, that is not misappropriated or misused by the users by giving them exclusive authorship over the works. My lords, furthermore, in the case of Eastman Kodak Company versus Image Technical Services Incorporation, it is a case of US Supreme Court, wherein the court emphasized that the protective licensing measures are acceptable if they are proportionate and do not unreasonably harm market competition. And similarly, in the present case at hand, the restrictions are necessary and reasonable in order to protect the proprietary aspects of the technology, and they are not unreasonably harming the market competition. The second pronged argument is that the licensing agreement neither causes appreciable adverse effect in the market and nor distorts competition. Any agreement regarding manufacture, distribution, storage, purchase, or control of goods or the provision of services that has or is likely to cause appreciable adverse effect on competition is considered as an anti-competitive arrangement under Section 3 of the Competition Act 2002. The licensing agreement specifically protects users from claiming full copyright, while it is not barring the users from using it for further generating the works or commercially exploiting the works within the licensed framework of the company, because it only targets the proprietary core, the algorithms and the training data, rather than completely restricting their innovation or competition in the market. There was a case of Apple Incorporation versus Pepper. It is also a case of US Supreme Court, because the international precedents have persuasive value. That's why we can have relevance from such precedents. And in this case, the Supreme Court also emphasized that only those licensing restrictions that unduly restrict market participation and it harms the competition, or if it creates entry barriers, that are considered as anti-competitive under the Competition Act 2002. And the restrictions that are only narrowly tailored to address the risk of IP misappropriation by the company, they have to be considered as reasonable and the necessary condition under the exemption of the Competition Act. And similarly, in this case also, the restriction was reasonable and not unreasonable, because it was imposed only with an intention to protect that the company's own data, the heavy investment that has been made by the company, it is not misused, diluted or misappropriated by the certain users. My lords, the fourth issue before the court is that the security breach at RoboMusic involved access to personal data related to the music preferences and users' interactions with AMIT. Does this raise any privacy concerns under the DPDP Act or under any similar statute, assuming if it is enacted? The council humbly pleads before the bench to consider that there has been a typographical error where the point, an argument related to this issue has been missed in the memorial. Therefore, the council urges the bench to please consider that argument.
Yes.
The alleged security breach that occurred in the servers of RoboMusic Private Limited, it has been wrongly presumed, raising concerns about the potential exposure of confidential user data. However, the assertion that users' data was actually compromised, it remains speculative. There is no conclusive evidence that the sensitive user information was actually misused and actually accessible to the third-party persons. Because in the Moot proposition, it is mentioned the data was potentially exposed, and as per the Black Law's dictionary definition of potential, it means existing in possibility but not in act, and naturally and probably expected to come into existence at some future time, but it is not now existing. So this particularly indicates and specifies that the data was not actually accessed or misused by anyone. It is only a potential exposure, and it cannot equate that the actual harm has been done to the users. And there were no, the prop is silent on the fact that the company has acted negligently, or it failed to implement any adequate reasonable security measures that was necessary to ensure the data was not misused or accessed to anyone. And the RoboMusic company has also not received any complaints from its users itself that their data has been misused or their privacy has been affected. That was it for the third and fourth issue. The council seeks permission to begin with the prayer.
Please.
Wherefore may it please the Honorable Supreme Court of Indiana, facts stated, issues raised, arguments advanced, and authorities cited, it is humbly prayed that the Honorable Court may be pleased, hold, adjudge, and declare that the AI-generated works cannot be protected under the Copyright Act, and they cannot be granted moral rights provisions, that the AI cannot be recognized as an author or co-author under the Act, that the RoboMusic's licensing agreement does not constitute anti-competitive behavior under the Act, and that the RoboMusic cannot be held liable for raising the privacy concerns under DPDP Act, and or pass any other relief that the Honorable Court may be pleased in the interest of justice, equity, and good conscience, all of which is respectfully submit. For these acts of kindness, the respondent shall duty bound forever pray.
You have filed any SLP, you have also filed, or you are only in defense?
We are,
Just wait. You are only in defense, or you have also filed, raised any new issue there, cross SLP, etc.?
we have only approached the court
So
in,
simple to say SLP be dismissed, be dismissed, that's all.
If you would have filed also SLP, then you should have prayed this.
All these declarations, why you are asking for any other prayer? So you are in a way, you are saying, we may accept any argument of
They
this.
want, they are right, because they want
Cost.
cost also.
So that should be, that should come out. That it should be dismissed with heavy costs.
Intelligent, not only dismissal,
This will, you will learn after practice.
but who has taught to do like this? Why this
No, it's
system
fine,
is
it's
like
fine, it's fine. It's
it
fine.
was a pleasure arguing before this court.
You are lucky you were last, that's why less questions. You asked, who are the first, how much questions my learned friend is raising?
Yes, any rebuttal? Come.
Good afternoon to the honorable bench. So, Your Honor, Your Honor, the counsel for the respondent spoke about how this IPR exemption was necessary because of the amount of capital which was put in. I would like to bring it to your notice that in the cases of Microsoft and Google in the European Union, the court had clearly held both of them liable, saying that amount of investment in technology in today's digital market is not a valid excuse for an IPR exemption, and they stated how the key word was protection as opposed to commercial exploitation. More importantly, Your Honor, in Amarnath Segal's case, there was unauthorized destruction of the work. Here, Thai Braza had a valid license to use the work, and thus there was no impact on reputation. More importantly, there's been heavy usage with respect to whether there was a minimal amount of creativity or not. And Your Honor, in the landmark judgment of Walter versus Lane, the reporter of a speech made by Lord Rosenberg was given authorship and the report was given copyright. Similarly, in Indian transcriptions also, such as if the Quran or the Bhagavad Gita translated, authors have been given copyright for the minimal use. More importantly, I would like to bring it to your mention that in the case of Liu versus Liu, their prompt qualified the level of skill and effort required for copyright protection, because copyright which was given out here met the threshold of originality. Here there is a lot of claims made about the amount of labor used. I would like to bring it to the court that labor does not have anything to do with respect to originality. You could put in a lot of labor, but you might still not meet the
Counsel,
threshold.
you know rebuttal means what? You are in rebuttal only.
Yes, I'm rebutting.
Answer if they have.
You are again re-arguing your case.
No, Your Honor, I do have certain things I would like to bring to your notice.
Come to that.
Only
Answer to their.
whatever they have said
Okay.
against that only.
Okay, Your Honor, in page 38 of the respondent's memorial, if they have cited the case of Apple Inc. Incorporation versus Pepper. Your Honor, the court out here ruled against Apple, saying that consumers who purchase any goods or services at higher than competitive prices from an allegedly monopolistic retailer might sue under antitrust law. And they stated how corporations such as Apple were violating competition law and consumers must be granted protection. Moreover, they in the same page they have cited Google LLC versus Oracle America, which is a case of copyrightability, and nowhere in the case they have mentioned IPR exemption under their
So
competition law.
you are equating yourself with the consumer.
Yes, Your Honor. And more importantly, if we go into the data privacy laws, I would like to bring it to your notice. 1 second, Your Honor. Yes, in page 41 of the memorial, They have cited the case of VM Morrison Supermarkets versus various claimants. Your Honor, this case has no standing in the present dispute, as there was an employee who went rogue and breached the data of the company. This is not a cyber attack, so I don't understand the relevance of this case. More importantly, they have cited the case of Smeaton versus Equifax Limited. Your Honor, this Equifax case is a 2013 judgment of the USA Supreme Court. In 2017, Equifax was fined $425 million by the USA Supreme Court for a cyber attack, which is very similar to this case. So that would hold more precedent. More importantly, coming to the competition law issue, Your Honor, page 36, when we speak about anti-competitive agreements, they have cited Section 3 of the Competition Act, but they have failed to cite Section 3(4), which pertains to anti-competitive agreements, but they have mentioned the case of Excel Corporation Limited versus Competition Commission of India as a main Indian precedent, which is where they mentioned there were 4 manufacturers of aluminide phosphide tablets which formed a cartel by entering into anti-competitive agreements. Your Honor, this is a case which is in reference to Section 3(3) of the Act, which deals with collusion and cartelization. So again, that would not be in consonance with the facts of the case, as we are not dealing with that. More important. Okay, last point to conclude, Your Honor. They are.
Let us see whatever.
Okay, just 30 seconds more.
Yes.
With respect to the data privacy laws mentioned, Your Honor, they have given more weightage to the Information Technology Act 2000. Your Honor, I'd like to bring it to your notice that Section 43A of the IT Act has been overridden by the Data Protection Act of 2023. So that which has a substantial part of their argument would hold no weightage, because the DPDP Act under Section 2U and Section 2T clearly defines personal data and confidential data and not sensitive personal data as by the United States. We have not adopted their jurisprudence, hence confidential data, and they have made a claim about how there's a potential exposure of data which might take place, but it is fair to assume that if a licensing agreement has been exposed publicly, the agreement would consider the person's name, age, or any other such details along with a certain license. Okay, I would like to conclude, Your Honor. It was a pleasure arguing in front of the court.
So, no, from your side, nobody has said that our case should be accepted. Your appeal should be accepted. No one has made this.
That XLP should be accepted.
Your Honor, I was going to say it, but then you said...
Say so.
I stop.
So told me.
That's why I am saying say so. Tomorrow they may not take this
Yes,
objection.
so I told me that.
All right.
Thank you so much.
Okay. So it's pleasure to hear both of parties.
You also want to?
No, sur again? It is a bit problem. Okay, fine. I never knew. It's fine.
My lords, as mentioned by the opposite learned counsel, that in the fourth issue we have given more weightage to the IT Act rather than DPDP Act, but it is immaterial that to which act the weightage have been given, because in the present case it is clearly mentioned in the Moot proposition that the breach potentially exposed the confidential user data. That means the data has not been actually accessed or misused by the users. And further, in the case of Apple Incorporation versus Pepper, on the page 38 of the Moot memorial, they have said that this case is not in the favor of the Robo Music company, but we have taken it the otherwise to relate it to our facts, because in this case, Apple forced users to buy apps only through their app store, which prevented third-party stores to download the apps. But in this case, there is no forceful implementation by Robo Music to that is preventing him to claim copyright, because that restriction was mentioned in the licensing agreement that was voluntarily signed by the Robo Music. Therefore, the restrictions and the whatever was there in the licensing agreement, it was clear and transparent, and it was with the consent of the Tayyab only. There was no restriction and forcible authority that was used over the Tayyab.
Thank you.
What about this Excel Corp case? They have the argument they say they took that it is covered under 3.3 and you have cited for 3.4.
My lords, the council is not aware of the facts in detail
Leave
right
it,
now.
no problem, leave it.
Thank you.
Thank you all. It was pleasure to hear arguments from both the parties. Judgment is reserved, of course, that will be pronounced later. No, that was, those were the instructions. So, thank you all. You have come up brilliantly. You have done very well. All the speakers and the audiences also. You have heard everything, every argument. It will also help you people.
Valedictory we will tell them.
That is there. No, but here in the courtroom, I have to say that they heard our arguments very patiently.
Not only this.
The lawyers don't
we
do
are
it.
in difficulty in passing the judgment because
Yes.
both parties were really.
Thank you. सीट वहाँ सारी सीटें वहाँ देंगे
ये कहाँ है आप इसमें कहाँ ये इनकी सीट कहाँ गई नहीं इनकी हाँ मैंने ले लिया है पानी की बोतल ले आओ बेटा
चाहिए, इधर 3 चाहिए। ये इधर एक रखा है। वो बीच में आ जाएगा। मैम एक ग्लास और चाहिए, एक ग्लास और चाहिए। अरे सर 2-3 वन मोर।
और एक नैपकिन ले आना इसको भैया, ये हटाओ वाला एक वो एल फोल्डर हटाओ यहाँ से, ये फोल्डर हटाओ। मेरे रूम में होगा, देखो ना टेबल पे ले आओ टिश्यू पेपर।
Good afternoon, ladies and gentlemen. With immense joy and honor, I, Navya, on behalf of the Faculty of Law, SRM University, Delhi NCR, Sonipat, takes immense pleasure to extend a very warm welcome to all of you present here for the valedictory ceremony of the first SRMUH Moot Court Competition 2025, hosted by the Faculty of Law, SRM University, Delhi NCR, Sonipat. It has been a celebration of intellect, advocacy, and critical reasoning over the past 2 days. Today, as we mark the grand conclusion of this prestigious event, we are privileged to be joined by legal luminaries and academic visionaries whose presence is truly inspiring. We are honored to have among us Honorable Mr. Justice Rakesh Garg, former Judge, Punjab and Haryana High Court, Dr. Adish C. Agarwal, Senior Advocate, International Council of Jurists, Dr. K.N. Chaturvedi, former Secretary, Ministry of Law and Justice, Government of India, Professor Dr. V.K. Agarwal, Pro-Chancellor, Jagannath University, Jaipur, Mr. Pramod Kumar Singh, former Secretary, Competition Commission of India and Senior Advisor, Axiom Law Chambers, Professor Paramjeet Singh Jaiswal, Vice Chancellor, SRM University, Delhi NCR, Dr. Vijay Kumar Singh, Dean, Faculty of Law, SRMUH. Now, I would like to invite our Vice Chancellor, Sir, Dr. Paramjeet Singh S. Jaiswal, our Head of Department, the faculty co-conveners and convener of Moot Court Committee, SRM University, to felicitate our honorable guests. Ladies and gentlemen, can we have a huge round of applause for our wonderful judges and chief guests? Now I would request our head of department to felicitate our Vice Chancellor, Sir, Dr. Paramjeet Singh Jaiswal. I now take great pride in inviting Dr. Vijay Kumar Singh, Professor and Dean, Faculty of Law, SRM University, Delhi NCR, to deliver the welcome address. Sir is a respected name in the legal academia with expertise in various fields of law, especially competition law. Under his leadership, the Faculty of Law at SRMUH has emerged as a growing center of legal excellence.
Thank you, Navya, for introducing the valedictory ceremony. We all know now this extravaganza which is happening since last 1 month. We have been doing this competition from February and now we are in March. This was a hybrid mode competition in which we started with an online session, and then thereafter we are meeting in last 2 days for conducting this session. I would like to welcome the Honorable Chief Guest of the event, Honorable Mr. Justice Rakesh Garg, former Judge, Punjab and Haryana High Court, Dr. Adish Shri Agarwal, Senior Advocate, International Council of Jurists, Dr. K.N. Chaturvedi, former Secretary, Ministry of Law and Justice, Government of India, Professor Dr. V.K. Agarwal, Pro-Chancellor, Jagannath University, Mr. Pramod Kumar Singh, former Secretary, Competition Commission of India and Senior Advisor at Axiom 5 Law Chambers. We are honored, sir, for your presence. You judged the final rounds of the competition, and it has been a great honor to have you all at the campus. And definitely my students as well as the participants from different parts of the country have been enlightened by your presence. And I would like to welcome our own Honorable Vice Chancellor. He doesn't require a welcome, but definitely we feel all honored whenever he is here in the campus as our father figure. And he keeps on inspiring us on different counts. So he has been having his own personal engagements, but on a Sunday he is here since morning, from the morning, and we are very thankful, sir. We welcome you here. We are thankful to our Honorable Registrar. He is busy with some activity. So we welcome him. I would like to welcome our all participants who have come from different parts of the country, all the quarter finalists. I would also like to update, and there will be a report soon by the convener of the Moot Court Committee about the complete Moot Court. But I would also like to extend my welcome, because we are going live with this particular session, and virtually our honorable judges who are in an online mode are attending this session. So about 34 judges who have judged the preliminary rounds. I welcome them also to this valedictory session. We have the quarter finalist and We have the session. There were about 6 judges in the semi-finals and the honorable judges in the finals. So this is the welcome which I would like to extend. With immense joy and gratitude, I extend a warm and heartfelt welcome to each one of you. Your presence has today added to the significance of this occasion, and we are truly honored to have such distinguished guests, esteemed judges, dedicated faculty members, and bright young minds as participants, as well as my own students with us. The gathering is not just an event, it is a celebration of learning, collaboration, and spirit of justice. So from the depth of my heart, I welcome you all to this valedictory session, hoping that this occasion will leave you with inspiration, cherished memories, and a renewed passion for the law. Definitely, we all have participated. We are waiting for the results and to hear the dignitaries, so I would not stand between you. But I would like to quote Henry Ford, who said, laws of together is the beginning, staging together is progress, and working together is success. So let us, with this resolve, begin with this valedictory session. Welcome you all again. Thank you.
Thank you, sir, for your heartfelt words and continued commitment to empowering legal minds of tomorrow. We now request Dr. Shubham Singh Bagla, Faculty Convener of Moot Court Committee, to present the Moot report and give us an overview of the competition's journey, challenges, and milestones.
Thank you for the invite, Ms. Navya, MC of the whole event, valedictory ceremony. It gives me immense pleasure, and I would like to welcome Honorable Justice Rakesh Garg, former Judge Punjab and Haryana High Court, Honorable Dr. Adish C. Agrawal, President, International Council of Jurists, and Reverend K. N. Chaturvedi, former Secretary, Ministry of Law and Justice, Government of India, sir. Honorable Professor Dr. V.K. Agarwal, Pro-Chancellor, Jagannath University, Jaipur, and Honorable Mr. Pramod Kumar Singh, former Secretary, Competition Commission of India, and Senior Advisor, Axiom 5 Law Chambers. In absentia, worthy registrar, he is busy. Esteemed dignitaries on the dais, respected faculty members, enthusiastic participants, and my dear students and friends. A very warm and distinguished welcome, and it gives me immense pride and honor that I stand before you today to present the report on the first SRMUH Moot Court Competition 2025, a landmark event organized by the Moot Court Committee, Faculty of Law, SRM University, Delhi NCR, Sonipat. This competition stands as a testament to our university's unwavering commitment to fostering legal excellence, advocacy skills, and academic discourse in contemporary legal challenges. The competition was meticulously designed to provide budding legal professions with an unparalleled platform to refine their argumentative, analytical, and research acumen, and moreover, it is engaged with intricate legal conundrums at the intersection of competition law, intellectual property rights, and artificial intelligence. This prestigious event was hosted in collaboration with SCC Online as our knowledge partner and SCC Times as our exclusive media partner, which reinforcing its academic rigor and national prominence. The structured format of the competition was crafted to rigorously assess the participants' advocacy, research, and critical thinking skills. The preliminary rounds were conducted virtually on 22nd and 23rd of the February 2025, ensuring widespread participation from across the nation. And the advanced round, including the quarterfinals, semi-finals, and the grand finale, were conducted offline at the campus of SRM University, Delhi NCR, Sonipat, Haryana. With an overwhelming response of 28 teams representing the finest national law universities, central universities, state universities, and leading private universities and law schools across the country, this competition transformed into a vibrant convergence of legal intellect, strategy, and persuasive advocacy. The inauguration ceremony held on 21st February 2025 at 2 p.m. was graced by an esteemed panel of legal stalwarts whose presence elevated the stature of this momentous occasion. The event witnessed the august presence of Honorable Justice Rajiv Sharma, former Acting Chief Justice of Uttarakhand and Punjab and Haryana High Courts, along with the Chief Guest of Honor, Honorable Dr. Professor V.C. Vivekanandan, Vice Chancellor of Hidayatullah National Law University, Raipur. Their insight and inspiring word sets the tone of the intellectually enriching competition. Our revered university leadership, including Honorable Vice Chancellor Sir and respected Registrar Sir, extended their unwavering support and encouragement, further strengthening our resolve to cultivate a dynamic mooting culture at SRMUH, Haryana. Moving to the advanced rounds, the top 8 teams from MNLU, Nagpur, Christ University, Bangalore, Jindal Global Law School, Christ University, Delhi NCR campus, IMS Unison, Dehradun, ICFI, Jaipur, Amity University, Noida. These are the quarterfinalists that we have. They demonstrated sheer brilliance in the quarterfinals, which was conducted yesterday, with a fierce knockout round leading to the emergence to our top 4 semi-finalists. The semi-finalists of first SRMUH Moot Court competitions are Amity University, Noida, UILS Punjab University, Christ University, Bangalore, and OP Jindal Global University. These outstanding contenders, after an intense battle of wits and advocacy, the finest 2 teams, OP Jindal Global University and UILS Punjab Universities, earned their rightful place in the grand finale. And this grand finale is really anticipated by all of us. One of the most defining aspects of this competition is the remarkable depth of expertise brought in by our distinguished panel, over 50 judges. Their collective wisdom and vast experience have been instrumental in upholding the highest standard of legal discourse throughout the competition. The panel comprised of eminent academicians who are shaping the future of legal education with their scholarly insights, renowned legal practitioners who tirelessly advocated for justice in court of law, and policymakers. We have also enriched by the partners of prestigious law firms like Khaitan and Company and Sujata IP and Associate, and among other we have ASA also, and many among others we have support of different law firms. As we stand on the brink of the final round and the valedictory ceremony, let us recognize and celebrate the hard work, dedication, and perseverance of every participant who has made this competition a remarkable success. Beyond the trophies and accolades, this journey has been about learning, growing, and refining the art of advocacy, an invaluable experience that we have undoubtedly shaped the future of every mooter here. So we have a look, let's have a short clip on what we have in our time span of the whole month that we have SRMUH Moot Court competition. Let's see the video here, please.
matches. One in an online mode where 28 teams competed against each other, and then we selected 8 teams which came here to our campus, beautiful campus, to compete. And we have found very exciting arguments happening by the teams, and it is indeed a privilege for us to host everyone here. And my team, organizing team of the Moot Court Committee, put its full effort in organizing the competition in a nice way. Many congratulations to the teams who have won the competition. We look forward to upgrade this particular competition in future and to have more number of teams. Thank you. All the best.
Thank you so much for all the participants to be with us. And now I would like to hand over the dice to the MC. All right. Over to you, Ms. Navya.
Thank you, sir. Thank you, sir, for your heartfelt words and your unwavering dedication and for taking us through the story of this landmark event. We are privileged to invite Professor Dr. Paramjeet Singh Jaiswal, Vice Chancellor of SRMUH, for the presidential address. Dr. Jaiswal is a stalwart in the field of legal education with a long career as an academician and as a man of law. Now I would request our guest of honor, Dr. Adish C. Agarwal, Senior Advocate, International Council of Jurists, to address the dais. Thank you.
Sorry for disturbance in this, and I'm thankful to Mr. Gurmeet Nehra who invited me. Just now at 2 I have to be on live on one channel, and then 3:30 that I request to change. I'm how I should start, whether with Professor Dr. Singh Jaswalji or my guardian, Justice Rakesh Gargji. Because Rakesh Gargji is in charge of our legal, and when we are in education institution, Vice Chancellor, Chancellor is the head of the. So, confusion, when we were judging, that was also difficult job, and here also, first whom I should address. So I'm jointly addressing, and Professor Dr. V.K. Agarwal ji, Mr. Pramod Kumar Singh ji, Dr. Vijay Kumar Singh ji, and Dr. Subham Singh Bagla ji, and Ruhi Khan, and dear students, other teachers, and students coming from different parts of the country. I feel proud that I have come to this university, which is headed by a real scholar, who is our, as I mentioned, Jaswalji, who is the recipient of National Law Day Award. And today, when we were judging this in final, as we mentioned that time, very difficult job, because both teams have prepared too much properly. But we have some criteria. What we see, the confidence. And beside that, little bit smiling, little bit, not, if it is too much, that will kill your case. That means that you are trying to influence, and especially the women, if they smile too much. So smiling too much is a minus, smiling little bit is very positive. And when we speak with confidence. And in college schools, if your number is first, then you are liable to be more grilled. Today, our 4 judges, they grilled the team, the first who were the counsel for the petitioner. And second team was grilled less. Why? When judges are also not too much aware of the case, so they seek more information. We try to be more aware of the facts and the law from those who are first speaker. You have seen the second team, respondent counsel, we raise less questions. Sometimes judges also tired. So that is the benefit. Yeah, he has to, yeah, only respondent has to settle the case of the petitioner. So when I was the vice chairman of Bar Council of India, we started this moot court competition. But when we were the student, we were not having this provision. So today's students are lucky that they are preparing for these moot court competitions. They are preparing, like earlier, annual day in schools, the teachers were preparing the students, parents. But now, teachers are helping the students to how to prepare their written, this plaint, etc., grounds. But sometimes, the mistake is committed by the teachers while preparing the moot court questions. Today, we were we were asking the council where you are taking this moral when there is no provision of in law. But we pointed out ultimately after so much grilling, then he pointed out, my lord, what I can do, it is in the moot question. So we never read. Judges never read. We just try to extract, especially a person of I never read because we are having face value. So in court also, when we appear, then if we are eligible for any relief, court is going to grant us. So I will not take too much time because I have to join two TV programs on Justice Verma. Thank you very much, and my congratulations to the teams who have won, but who have not got this. This is an opportunity for them to prepare better. Be confident. Once you are confident, then judges will feel that you are telling the correct law. But if you are not confident, then we will catch hold that he is not aware, then we will try to catch that we will highlight. And we are not good lawyers. Today's lawyers are the best. Although I'm a lawyer enrolled in 1978, we are not having such proficiency what you are having. Because today's generation has the best avenues what we were not having at that time. So congratulations to all, because you who have not got the prize, you got the opportunity of learning by joining this moot court competition. Thank you very much.
Thank you so much, sir. Now, I would like to invite our Vice Chancellor, sir, Professor Dr. Paramjeet Singh Jaiswal, Vice Chancellor of SRMUH University, for the presidential address.
A very good afternoon to all of you. In fact, it's my honor and a privilege to welcome my very, very old friends who are sitting on the dais. Honorable Mr. Justice Rakesh Garg ji, former Judge Punjab and Haryana High Court. Professor V.K. Agrawal ji, who is the Pro-Chancellor of Jagannath University now. Prabodh Kumar ji and Chaturvedi ji, who is not feeling well, but he is sitting in the adjoining room. Adish Agrawala, who had to leave just now. Thank you so much for accepting our request and coming over to judge this moot court competition. I always say that mooting is now integral part of a curriculum of the law studies of the law schools or the law colleges. As Adish ji said, that this is a platform, it is an opportunity where you can show many of your talents. For example, what is the confidence you have, how you can rebut the arguments of the opposite side, how can you express yourself on the spot to or respond to the question which are asked suddenly by the judges. Yes, in every competition, ultimately one team has to be declared as the winner, the second team has to be declared as the runners-up, but I say no competition is possible unless you have the participants to compete. So all the participating team, that is the starting point for your winning the competition. Yes, you might have lost in the beginning to your other team because that was better prepared. But what you learn is that what are the nuances where the opposite team was better. You can prepare better next time, and you never know the next competition, you may be the winner. I must compliment all the participants, particularly those who have come for the physical mode from quarter-final to the final yesterday and today. They came from their respective institutions. Thank you to all. If there were some drawbacks here in your stay arrangement or other, I take the responsibility to myself, being the Vice Chancellor, but we tried our best to see that you are comfortable here. In the moot court, I had the opportunity to listen and see the participation from the adjoining room, because this was live competition. So I could see the talent in the teams, both the teams, how they were representing their skill to express their preparation or the point of law or the facts and responding to the question. I'll just give one advice. The better advice can be given by the Honorable Judge or the practicing lawyer, Adish ji has already given. In the court, the most important is your mannerism. As far as the winning and losing the case, a particular case is concerned, it depends on your preparation, your grasp of facts, your grasp of law. But your court mannerism is very, very important. And it is said that when you are in the court, don't concentrate on winning and losing. You may lose the case, but you should never lose the court. Many good lawyers who are very competent, they sometimes get angry in the court, they argue with the judges, and that leads to the negative direction, and they lose the case, which is a winning case by all means. So you may lose the client, but you should not lose the court. You may lose the case, that doesn't matter, but you should never lose the confidence of the judges and the confidence of the court. That is very, very important, and that is why even in a law school, when you come, we try to teach you the discipline. First thing we ask the student, which the student do not like, we also have been a student like you, that yes, you must come in uniform. You say, why should we wear the uniform? That is nothing but, we are trying to train you to how to be a disciplined. You represent one of the most honored profession in the world. Lawyers, I don't know whether you know it or not, lawyer and doctor, they are the only two professions. In the hospital, when the patient is dying, they bring the paper and they ask, you sign here, give your consent. The operation is to be done. Who is doing the operation, you don't know. What is the operation, you don't know. You never read what are the conditions. But you are dying, you are on the stretcher or a table OT, and then you sign the paper. But a lawyer, a step further. When you go to a lawyer with a case, the lawyer, after listening the case, settling the fee, they will give you a blank paper. And they say, we may need your statement sometime to support the brief. So you sign on the blank paper. So in the hospital, you signed on a printed lines, but the lawyer chamber, you sign on the blank paper. But see the greatness. We have never ever, at least I have never ever come across any case where any lawyer has misused that blank paper against the same client. That is the kind of a confidence, that is the kind of a faith in the professional and the professionals. So keep that faith high, be disciplined, and give full respect to the court. That is my advice to the young budding lawyer. And thank you so much for demonstrating your skill, ability to argue in a real court-like situation. Congratulations to all the participants, and in particular those two finalists. I do not want to stand in between you and the rest of the program. So thank you once again.
Thank you, sir, for sharing your vision and for constantly guiding our institution with your insightful leadership. Now, I would like to invite Professor Dr. V.K. Agarwal, Pro-Chancellor, Jagannath University, Jaipur, to share your words of wisdom, sir.
Good afternoon to one and all. Namaskar. India is the youngest country, and the youngest country cannot afford to sleep like this. Namaskar. That should be the Honorable Mr. Justice Rakesh Garg, former Judge Punjab and Haryana High Court, Professor P.S. Jaswal Sahab, Vice Chancellor of this great university, Professor Mr. P.K. Singh, who has been the Secretary in the Competition Commission of India, Dean, Faculty of Law, V.K. Singh, learned faculty members, dear participants and students. At the outset, I express my deep sense of gratitude and thanks to your Vice Chancellor, who provided me this opportunity to be the part of the panel to judge the final round of this competition, and also to be the part of this valedictory function. You know, this moot court competition, which was the first one, it is a very good beginning. I must congratulate the Dean of the Faculty and his team for organizing such a wonderful event so successfully. Let us give a big round of applause to him. I also extend my heartiest congratulations to all the winners, except the winner of the final team, which will be announced by the Honorable Judge. And my special congratulations to all the participants. As Professor Jaswal rightly said, that participation is more important than winning or losing. You must have realized that merely by participating, you must have got some confidence, some additional knowledge, art of advocacy, court manners and etiquettes. This is a learning process for you. As regards the moot problem is concerned, it was very well framed, primarily dealing with three legislations: Copyright Act, Information Technology Act, and the Competition Act 2002, which has drastically been amended in 2023. So those who have drafted this problem, and particularly that they have very well correlated artificial intelligence with these three legislations. That is really remarkable. So I also congratulate those who have drafted this problem. Really a very good problem drafted by the drafters. I don't know who have drafted this. And as regards the quality of this competition is concerned, I can say it was par excellence. The way the participants have prepared their case, the way they have built up their arguments, supporting with the statutory law and the case law, was really remarkable. And particularly and most importantly, the way they have handled the questions raised by the bench, it is hats off to them. I know that this moot problem was a very complex one. It was not an easy one to handle, but you very nicely handled the bundle of questions which were, the bundle of questions, the bundle of queries which were raised by the judges, and you were maintaining your cool and calm. This shows that you are going on the right path. We are living in IT era, and today, the tons of information is available at the click of the mouse. But what is important? How to handle that information. First, you should verify the veracity of that information. Two, you must be able to analyze that information. And three, how to make use of that information in live examples or live cases. Then you can make use of IT in a wonderful way. I generally say the Honorable Judge is here. He may please excuse me. Today, the courts are no more the courts of justice. They are the courts of law. I'm with humble, apologies. Okay. You see, yeah. You see that in the court, the laws are discussed by the advocates and the judges. Client doesn't know what is going on. And he is not concerned with law, he is concerned with justice. I'm reminded of an incident which happened in Punjab. In a district court, a young boy was caught in a murder case. He was not having his father, very poor family. His mother was there. And finally, after the trial, he was sentenced to death. That boy was sentenced to death. The mother who was sitting in the court, she cried, "Judge Saab, insaf nahi hoya." She knew that her son is innocent. You know what the judge replied? Mataji, ਅਸੀਂ ਇੱਥੇ ਸਾਫ਼ ਨਹੀਂ ਕਰਦੇ, ਅਸੀਂ ਤੇ ਫੈਸਲੇ ਸੁਣਾਉਂਦੇ ਨੇ. We do not do justice, we just pronounce judgment. So, the hope which is from the young generation sitting in front of me, the budding lawyers, hope that you will reverse this process, making the courts of law to courts of justice. Another important thing which I always say, law in books is different from law in action. You know, there is a law on every packet of cigarette or bidi, there should be a caption, there should be a warning, a statutory warning. Smoking is injurious to health. We all know. I'm able to recall an advertisement which I used to see in the theater when we go to see a movie. There's a fire in a house. A young girl is left. All others have come out. Everybody is crying, "Save her life, save her life." A young boy jumps into that house and brings her out, and her life is saved. Everybody is very happy. The life of the girl is saved. Somebody asked from the crowd, "Where is that boy who has saved her life?" And you know, the boy is standing under a tree, smoking. Caption, "चार मीनार पीने वालों की बात ही कुछ और है." Another caption, statutory warning, "Smoking is injurious to health." I don't know what to follow. What to follow? The statutory warning to follow, or the heroic work which they are showing in the advertisement? This is what the contradictions in the law which we study in books and the law which we implement. You see that it is said the life of an advocate is not a bed of roses. Either there are all roses, no bed, or all beds, no roses, and in the beginning, neither roses nor bed. So, obviously, it is a very good profession. Professor Jajwal may get offended if I say the culture of national law schools, which have introduced 5-year course. Generally speaking, without any derogatory observations, there's no derogatory marks on anybody, national law schools are producing corporate lawyers. The real lawyers are being produced by the traditional universities, maybe government or maybe private. And the kind of thrill which you will enjoy in practice, that thrill you cannot enjoy as corporate lawyer. Every time you are getting a new kind of problem, a new kind of case. So there's no parallel to that. If you really want to enjoy your what knowledge you have got as law graduate, that you will enjoy only as the practicing lawyer. So with these brief observations, I wish all the budding lawyers a very bright future. Thank you.
Thank you, sir, for inspiring and motivating us with your words of wisdom. Truly, sir, we hope to make the courts of law courts of justice one day. Now, I would like to invite Mr. Pramod Kumar Singh, former Secretary, Competition Commission of India and Senior Advisor, Axiom 5 Law Chambers.
Honorable Justice Rakesh Garg, Professor V.K. Agrawal, Professor Dr. Paramjit Jaswal, Professor Vijay Kumar Singh Dean, at the outset, I congratulate Faculty of Law, SRM University, for organizing this Moot. I congratulate Faculty of Law, SRM University, for organizing this moot court competition, which will go a long way in increasing awareness about competition law, its interplay with IPR and AI-related laws among the law students and other stakeholders. I had the benefit of joining CCI since its inception and worked there for more than a decade in different positions and contributed my bit in establishing the new organization. I would like to share that your Dean, Dr. Vijay Kumar Singh, has been my former colleague in CCI for many years. In the initial years, in the absence of any jurisprudence, we used to engage in intense debates internally to decipher, to understand the meaning of each and every term, word which is used in the Act. For example, Section 2H of the Competition Act defines enterprise. So which enterprise, what entities will be covered under that definition, which will be excluded, then how the trade union, trade associations, they can be covered under the competition law. Very fascinating law, and we really enjoyed. As the awareness about the law and institution spread, CCI started to examine cases from diversified sectors like film and entertainment, commodity like cement, steel, sugar, alcoholic beverages, railways, airports, real estate, pharma, insurance, sports, automobiles, to name a few. As markets are dynamic in nature, new types of markets are opened up and new products and services are introduced in the market, throwing different and complex challenges for the CCI to assess market dynamics and address market failure using conventional tools. Introduction of e-commerce, app-based delivery system, messaging apps, and presently hotly debated AI and generative AI are disrupting the markets in myriad ways. Because of fast changing nature of the markets due to technological developments, need is felt across the globe to deal with the ever-evolving digital markets, to modernize their laws, including competition law, to deal with the ever-evolving digital markets. In India also the Competition Act was recently amended, as Dr. Agrawal pointed out, in 2023. And new concepts like leniency plus, settlements and commitments, hub and spoke cartels, and penalty on global turnover, and deal value transaction threshold was introduced to capture acquisitions and mergers in digital space. Still few questions remain to be answered, like how to capture AI facilitated collusions without any human intervention. Similarly, because of the work created or generated by LLM-based generative AI are throwing challenges under IPR law, like the one discussed today in Moot court problem. Additionally, with a view to regulate digital markets, Digital Competition Bill has been introduced, which will regulate large tech companies on ex ante basis. Some countries have taken lead and have already enacted legislations to ex ante regulate so-called gatekeepers in digital space. EU is enforcing Digital Market Act. UK also enacted DMCC Act. Competition law is an economic law and is based on certain sound economic principles. The benefit of the competition in markets are now rarely questioned. As we all know, fair competition results into lower prices, wider choices to the consumer and leads to efficiencies and innovation. The Competition Act follows the philosophy of modern competition laws and prohibits anti-competitive agreements and regulates mergers and acquisition. CCI is empowered to impose substantial monetary penalties which may extend up to 10% of the global turnover. The law is also unique in mandating competition advocacy by the Commission with the stakeholders. The law is applicable across the sectors and to all enterprises, including state-owned enterprises and commercial activities of the government-related bodies. In this sense, the CCI is a market regulator. Then apart from CCI, many sector-specific regulators are mandated to regulate and enforce their respective laws. IPR-related laws are enforced by different forums. Copyright Act was enforced earlier by Copyright Law Board, then IPAB, and now commercial courts in High Court. Similarly, Patents Act is enforced by Comptroller General of Patents, Design and Trademark. Presence of sector-specific laws and sectoral regulators also give rise to jurisdictional overlap, and matter is often challenged before constitutional courts. Although in case of conflict between competition law and other sector-specific law, a resolution mechanism is provided in Section 21 and Section 21A of the Competition Act. In some recent judgments, the High Courts and Supreme Courts have tried to resolve the conflict by interpreting the law and roles of CCI and sectoral regulators. In Airtel case, the jurisdiction over subject matter was clarified by Supreme Court. The interplay between intellectual property rights and competition law is crucial for fostering a competitive and dynamic economic markets. Before I conclude, I would like to say that balancing the protection of IP and the need for innovation is increasingly complex in the age of AI. And this is evident elsewhere in the world in recent legal battles. and blindly trusting AI output is fraught with danger for legal professionals, as happened with the lawyer of Donald Trump, now President of USA. When Donald Trump's former lawyer, Michael Cohen, was found guilty of submitting citations of non-existent cases, or what the court later referred to hallucinations, Cohen chose to plead ignorance. This was despite the fact that he was the one who sourced the citation through the open search Google Bard, now Gemini, a multimodal large language model of artificial intelligence. Cohen's lawyer took the fall as the judge admonished him to verify AI-generated law citations. Commenting on the lapses, US Supreme Court Chief Justice John Roberts described AI as a mixed blessing that ought to be used with caution and humility. Roberts highlighted both the efficiency AI can bring to legal processes and potential risk of over-reliance on AI-generated content. With these words, I conclude and once again commend the law faculty of SRM University for organizing this interesting and useful moot court competition, which would help the participant in understanding the regulatory framework and nuances of competition law and other related laws, and taking it forward from here. Thank you.
Thank you, sir, for your wonderful insights on competition law. It is now my privilege to invite our chief guest, Honorable Mr. Justice Rakesh Garg, former judge of Punjab and Haryana High Court, to address the gathering.
Before I start my so-called address, I must ask one question from all of you. Who is the odd man out at the dais? Can you tell anyone? So I can answer this. I am the odd man out. All the educationists or the leading persons from the faculty, etc., are sitting there, whereas a simple man with the background of agriculture, he is there. I cannot speak like them. I am not trained in giving lectures. I must tell you people. So whatever I will be saying today, that is only I will be sharing my own stories, my own experiences in this noble profession. Nothing else. At the outset, I am thankful to Vice Chancellor Sir, Mr. P.S. Jaswal, who gave me this chance to be with you, all of you, especially with the young people. And I also feel very energetic and young, being in one of them. My relationship with Mr. Jaswal goes back to 1974, or 75, I can say. I graduated in 75. So thereafter, I was always there in his room. No, but it's customary to say something because I am the chief guest designated today. So, but I have not prepared any lecture. Anyways, Mr. P.S. Jaswal, Vice Chancellor, Mr. Agarwal, the Pro-Vice Chancellor, Pro-Chancellor of Jagannath University, Jaipur, Mr. Pramod Singh, who was formerly with the Competition Commission of India, Mr. Adish Agrawala, and Mr. Chaturvedi in absentia. Dean Faculty Law, Professor Vijay Kumar, all the faculty members, Navya, who was here, students, participants. I'm very grateful to be here, to all of you. Much has been said about the moot courts, etc., and the subject. I don't want to repeat that. But I must say, the participants, were very well prepared. Each one of them, all the 4 participants, or maybe the researchers who were sitting there, all were well versed with the problem. In fact, if they can make me understand such kind of complex problem, they can definitely convince the judges also whenever they are going to argue. I must admit that it was a new law for me, but they have made me understand this. So that's why I was able to ask some questions from them. Otherwise, my work was made very easy by friends at the bench. Anyways, moot court is an essential part of today's training, and in fact, it's very helpful in shaping the skills of a budding lawyer or of a future lawyer. And you are lucky that you are getting such kind of training and all kind of facilities at this university, which I don't have any doubt. I'm not saying that it is going to emerge. It has already emerged as a leading private university in the area. And in near future, under the able guidance of Justice Mr. P.S. Jaswal and the other faculty, it is going to grow beyond even boundary of the country. Having said so, I must now say to the students, to the future lawyers, that the key to success is only you must work very hard. In this profession, hard work is the only key to success. Nothing else. Even your knowledge of law will come from the hard work which you are doing. One more thing which I would like to say, that you must be very fair and honest to the court, and only then you will be able to get relief for your client. As it has been said, that winning or losing of a case is not that important, but if you lose a court, a lose a judge, you are definitely going to lose much more. I must say that you are lucky that these days you are having all kinds of tools for sharpening your skills. Whereas in our times, it was not like this. What to talk of moot courts or the regular lectures? We used to skip classes. Can you believe that my father was not even knowing that I am studying law? If I am going to tell you a story, maybe it's a true story. A boy who who matriculated and then got admission in a nearby college, because parents were not allowing him to go beyond the, you can say, 10 kilometer or 15 kilometer radius, because he was the son who was handling all the properties of the family and who was also responsible for day-to-day running of the house, which includes 2 elder brothers who were studying, one was studying medicine and one was studying engineering. After graduating from the nearby college and also cultivating his lands, the boy wanted to do something more, but the parents did not allow. And in those circumstances, that boy got admission without telling his father in a nearby state in law and got the degree after 3 years. Thereafter, he was lucky again, but I can say he was destiny's child. He was going to Chandigarh, etc., and he came into contact with students who were preparing for competitions and but slowly and slowly, and maybe for 2, 3, 4, 5 years, 6 years, everyone was settled. Somebody has gone to IAS, somebody has gone to PCS, and somebody became a lecturer in the law college. And the only one, that boy was left. But one day, he started his own practice. For some reasons, he shifted to Chandigarh and started practice. And sheer work, hard work. When he joined his office, he told his senior that he knows not much about law. But his senior told him, don't worry, work hard. But there is no shortcut. No shortcut to success. You have to go straight. And he was right. And that boy, who was that boy? He is standing before you today. This is the real story. I never knew that you will come again. So, from my experience, I am telling all of you students, dear students, that success is bound to come if you are working very hard. If you are working hard, this is the fact. This is the fact, I must say. When I say that that boy is standing before you, then nothing remains. So make your work as a passion. Treat it as, do it with the passion, and nobody can stop you. There is always a vacancy at the top. So with these words, I must again thank all of you that you have given me this chance to be before you people today. And I wish all the success to all of you. Thank you. Now the results which you are probably waiting.
I would request all the
Okay, then I can pronounce from there only.
So I request all the dignitaries so that the result can be announced.
Okay.
A hand mic should be put. So this is to be with you. Yeah, too.
प्राइसेस तो बाद में नहीं देंगे बाद में देंगे
अभी देना अभी आप ही करेंगे सर वो आगे सर
the results. Okay. So the winner is serial number 1, O.P. Jindal, Global University.
So there are no surprises. Take directly because we are going ahead with. Please come.
But where is the team runner-ups?
So they will come, sir.
Okay. No, I just wanted to say they were not less than them. I must say maybe a very, you can say 1/100 part, you can say they were, otherwise you are both, all the 4 speakers, they were equal. You stood the ground, that was your best defense, best thing.
So the winner is O.P. Jindal. Thank you.
स्टेज पे सारे नहीं आ पाएंगे सर, यहाँ से करेंगे सर, बेटर आ जाएगा आप लोग सब, क्योंकि ये आप लोग सारे, हाँ आप लोग यहाँ लड़ेंगे, यस नाउ इट विल बी बेटर सर, थोड़ा सा आगे हो जाइए, बीच में आ जाइए।
The first runner-up of the first SRMUH moot court competition is University Institute. The first runner-up is University Institute of Legal Studies, Punjab University. Team comprising of Yuvansh, Chahat and Disha Jain. The second runner-up is Amity Law School, Noida, team comprising of Karan Verma and Vidhi Saxena. Amity Law School, Noida. Now the next best memorial trophy goes to IMS Unison University, Dehradun, team comprising of Harshita, Munib and Arjit. हाँ सर ये आ गए नेक्स्ट बेस्ट मेमोरियल The best speaker of the first SRMUH Moot Court competition is Pranav Srivastav, MNLU Nagpur. And the best researcher trophies goes to Vasundhara Shekha. Speaker. Yes. The best researcher of first SRMUH Moot Court competition is Vasundhara Shekhawat, ICFI Law School, ICFI University, Jaipur.
And the certificate of appreciation for being in the quarter-final rounds goes to SN1 OP Jindal, Parvarti, Siddharth and Sneha. Certificate of second, SN2 Harshita, Munib and Arjit. SN2 Harshita, Munib and Arjit, kindly come here for your certificate of appreciation. Team code SN3 Arjit, Priyal and Prakrti. Priyal, Prakrti and Vasundhara. Followed by SN4 Pratham, Anmol, Aditya. Followed by SN5 SN5 Yuvan, Shahat and Disha. Yes. Next SN6. Next इसके बाद. SN6 be ready. Priyank, Karan and Samarth. Next SN7 Pranav, Himang, Samruddhi. And SN8 Karan and Vidhi from Amity Law School, Noida. We have Pranav, Himank and Samruddhi from MNLU Nagpur. Next is Karan and Vidhi. Yes.
Yes, sir. Now I would request the honorable dignitaries to felicitate our faculty conveners of the Moot Court Committee, Ms. Rufi Khan and Dr. Shubham Singh Bagla, and the student conveners, Ruhani, Sarthak, and Shimon. A huge round of applause for the faculty conveners and student conveners. To express To express our gratitude and appreciation, I now request Ms. Rufi Khan, Faculty Co-Convener of the Moot Court Committee, to deliver the vote of thanks.
Good afternoon, everyone. I would like to extend my heartfelt gratitude to all our dignitaries. Thank you so much, everyone, for gracing this occasion. Thank you. Thank you so much, sir. And I would like to, we are like really indebted to our respected Vice Chancellor, sir, and our Dean, sir, for helping us so that this occasion is a huge success. Thank you so much, and all the faculties and all our students who were there since past 2 months, who have worked dedicatedly to make this occasion a success. Thank you so much. Thank you so much. Sir, I mentioned it is because of the students from the past 2 months who have worked so much so that this event is a success. So they are there. Thank you so much, sir.
With this, we conclude our valedictory ceremony. We now invite all our dignitaries, participants, and guests to join for the lunch. Thank you. I request everyone, participants and all student volunteers, I request all of you to stand for our national anthem.
जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमालय हिमाचल यमुना गंगा उच्चल जलधितरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I would request all the winning teams, the participants, and the student volunteers along with the faculty to proceed for the group photograph. After that, you may proceed for the lunch.